based on your driving record, I can tell you that the Secretary of State is going to send you a letter that will tell you how to take an online traffic safety class to keep the points from going onto your record. It doesn't take the points off, it stops the points from ever going on. It's a once-in-a-lifetime opportunity.
Yes, sir.
For a driver with a good record who is cited with a civil infraction that carries 3 or less points, not including careless driving. So do you still live on Lorraine?
Yes, sir.
That's the address to which the Secretary of State is going to send a letter. Now, on this matter, the court's consequences amount to a fine, and the fine is $130. That can be paid online or by mail, or if you chose, you could pay it at the courthouse counter. Now, if the Secretary of State's a little slow in sending you the letter, that's not a problem to you because they will not give you the points until you've had the chance to take the class. And I want to repeat, the class doesn't take the points off. It stops the points from ever going on. So what's your mail from the Secretary of State, because it's going to be good news.
Okay, sir. Thank you, sir.
Thank you.
And
Have a good day.
so when I need to pay, sir?
Well, if you were standing in the courtroom, I'd say you can pay as you leave, but what kind of time do you need?
I'm at home at this moment, sir.
Right.
So if you give me like a 1 or 2 weeks time, it will be nice for me.
Sure, we can go 2 weeks.
Okay, sir.
Good. 2 weeks to pay. You are good to go, sir. Have a good day.
Thank you, sir. Bye.
Mr. Manoogian. This is file 2502-071, People's City of Berkeley versus Lyrical Johnson.
Good morning, Your Honor. Max Manoogian appearing on behalf of Lyrical Johnson. Today is the date and time set for an arraignment on this matter. We waive a formal reading of the charges, ask that a not guilty plea be entered. Ms. Johnson will be requesting a state-appointed attorney, and we do consent to holding the hearing on Zoom.
Thank you. Plea of not guilty does enter. We'll set this for a pretrial. You'll be notified.
By Mr. Staten. We have Mr. Harris in the prosecutor's office. We're here today for a pretrial. It's my understanding Mr. Smith's going to enter a plea of guilty to 1 count of harassment with a bodily substance. We're going to go forward with sentence today. Is that accurately stated?
It is, Your Honor.
Yes, Your Honor. Mr. Smith, how old are you?
26,
How far did you go in school?
11th grade.
Are you able to read and write English?
Yeah.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No, sir.
Are you a United States citizen?
Yes, sir.
If you enter a plea of guilty to this charge, I'm going to sentence you to 6 months consecutive to the time that you're already doing, and I'm going to make a finding that you are indigent for the purposes of fines and costs. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. Looks like on the second page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Staten before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of guilty to 1 count of harassment with a bodily substance, 5th-degree felony, punishable by up to 12 months in prison and a $2,500 fine. It also carries with it an optional period of post-release control of up to 2 years. Before we go any further, Mr. Smith, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to this 6-month sentence. Is that what you want to do?
Yes, sir.
Mr. Harris, what are the facts?
Your Honor, if this matter proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about April 30th of 2025, Lebanon Correctional Institution in Warren County, Ohio, Deontay Smith expelled a bodily substance on a corrections officer. This specifically the defendant spit on Corrections Officer Magnus.
Any on those facts, Mr. Staton?
No, Your Honor.
Mr. Smith, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes, sir.
Do you understand the rights you're giving up by entering a plea?
Yes, sir.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. Is there any reason not to go into the matter of the sentence today?
No, Your Honor.
We have 0 days of jail time credit and no restitution, right?
Correct.
Anything else from the state?
Just ask the court to adopt the recommendation of the parties of 6 months consecutive to the time he's currently serving.
Mr. Staton,
I would join in that, Your Honor.
anything you want to tell me, Mr. Smith?
No, sir.
I am going to sentence you to 6 months in prison. That is going to be consecutive to the time that you're already doing, because your record suggests that a consecutive sentence is necessary to properly punish you, to protect the public. The overall sentence is not disproportionate to the conduct involved here or the danger posed by you. This includes an optional period of post-release control of up to 2 years. And I find that you're indigent for the purposes of fines and costs, so there will be no financial sanction. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs, they'll all be provided to you without charge. Good luck to you, Mr. Smith.
Yes, sir. Thank you.
Thank you, Your Honor.
All right. Thank you.
Good luck to you.
Yes, sir.
People versus Gamble.
Ready, Your Honor.
Good morning, Mr. Dabolsky. How are you? Happy New Year. I haven't seen you since the first.
One thing, you got my.
Morning.
client scene. Line.
What's that?
You were able to steer my client scene right in line as cooperating with the probation department.
Good, good. Is he the guy that was just blotto the first time you brought him in here? Yeah, he's been doing really well.
He's like,
Oh, this is the guy that we couldn't get a hold of. Yeah,
both of them are.
good, good.
Morning, Your Honor, for the record, on behalf of the defendant, Your Honor, there is a plea agreement in the file that my client was responsible for the total.
Yep.
$500 fine.
All right, we'll do the double parking on the civil infraction. All right, Miss Gamble, is that your understanding of the agreement? You've agreed to pay $500. All right, I will accept that plea. I'll dismiss both the original charges. Can you pay the $500 today? Yeah, but understand that we don't do all this disposition until we get our money. So if we don't get the money within that due date, you're back dealing with all this. All right. So I can do you 30 days. Can you remember that? All right. So I'm not going to send you downstairs to do any paperwork downstairs. Just you get that paid within 30 days.
Thank you, Your Honor.
All right. Good luck. Always.
For Sumter, is it the new guy or is it? not?
Both are here. Oh, that's right. People versus miracles.
Right, Judge.
Morning, counsel.
Morning, Your Honor. Joseph Hall, appearing before and on behalf of here. Is now standing to my
Morning.
left, Spirit will say your name on the record. And Your Honor, I believe we do have a resolution contained in the file executed by my client, whereby he is going to plead guilty to 1 count of driving while license suspended. In exchange for that, the companion case is going to be dismissed. And as to the DWLS, the ticket along with that DWLS
Speeding.
is already defaulted in and I believe it's written up accordingly.
So you're asking me to set aside the default and dismiss?
Yes.
All right. Mr. Miracle, did you discuss your rights and options with counsel today? You understand all those? You understand understand the possible penalty for the charge of a license suspended, revoked, or denied? And understanding all that, are you in fact pleading guilty to that charge today?
Yes.
On October 2025, did you drive a vehicle in here on Township?
Yes.
And at that time, was your license suspended, revoked, or denied? Counsel satisfied?
Satisfied, Your Honor.
So am I. I'll dismiss the two charges from August 6th. What's the status of the license now?
I'm both currently, Mr. Miracle is not fully in Wayne County, for
I just would like a new attorney because it's just a lot of things that's going on with my case that I see is not right. And it's just not going nowhere.
Okay. Well, Mr. Everhart, the way this works is, there's three ways that this can come out when we go to trial. First is it can be represented by a lawyer that you hire. You can hire whoever you want. Second is you can represent yourself. That's a terrible idea. The third option is for me to appoint a lawyer for you. I appointed Mr. Helbling to represent you in the case. I get, Mr. Everhart, not every attorney is right for every client. Not every client's right for every attorney. I used to do the kind of work that Mr. Helbling does. I was on this court-appointed list for 10 years probably. So I get sometimes it's not a good fit. But I just want you to understand, I'm going to appoint a new lawyer for you today. That's the last lawyer you're going to get from me. So if you can't get along with this next person, your option is either to represent yourself or hire your own. Do you understand that? All right. We do need a new affidavit of indigency. Who are we appointing, Ms. Kurilko? All right. I do find that you continue to be indigent for the purposes of hiring a lawyer. I'm going to appoint Mr. Kirby to represent you. We're going to give you his contact information there. We are also going to send him an email today that lets him know that he's been appointed. Mr. Helbling, do we have discovery, like thumb drive discovery, that kind of stuff that we can get to Mr. Kirby?
Yes, I can get that to him.
Okay. If you want, if you're comfortable leaving that with Ms. Kurilko, she can pass that along to Mr. Kirby,
I think,
or you can get it directly to him. Doesn't matter to me. I just want to make sure that the discovery gets handed off.
yeah, I'll give it to him directly.
All right. I'm going to set this for another pretrial in a couple of weeks. Let you and Mr. Kirby get to know each other and at least initially talk about the case.
Your Honor, for
Hawthorne, you wanted to talk to Mr. Hawthorne and review some discovery before we did something today, right?
yes, Your Honor.
All right.
We received that video.
All right, we'll do this subject to recall. So whenever you're ready, let Ms. Kurilko know.
Okay.
We're already set for trial, so we don't have to recall the case. But if you want to recall the case, I'm here.
Yes, I would like him to see that. And then
Okay.
I have some discussion with him. Thank you.
All right.
We're going to go back to the same stuff.
We can probably,
I think
do you want to
somebody
do it
needs
in
to
here?
escort
It doesn't
him
matter.
It does impact his license. He understands that this will constitute the violation of probation that he is on and is prepared to deal with that through my office.
Okay.
As well as he's committed, Your Honor, to when he is first eligible to coming back, and he knows I do these and helping him to get full license restoration. I look forward to that.
Okay. That bottom pan scribble, does it say no payments posted? Okay. Are you working, sir? What do you do? What do you do? Okay. How long?
2012.
Okay, you working now?
So
Are you working now?
currently not working. We got work just with the weather.
Yeah, so you're employed, you're just waiting for it to be above zero, right? Okay, all right,
Well,
yeah. Tangent alert. So a number of years ago, I met a guy, mutual friend had a party. So I met this guy. He was a retired carpenter. He's from Michigan, moved to Alaska, was a framer in Alaska, and then moved back, you know. So I'm talking to him. I grew up construction, so I'm talking to him. And I'm like, how long is your building season in Anchorage? He said, what do you mean? I'm like, well, you know, do you just build like from June, July, and August? Or he said, no, we build year round. I'm like, man, I could never get a handle on working with gloves, you know, nail pouches and gloves. And he said, me neither. That's probably why these don't work anymore. Because he worked year round in Anchorage, Alaska. He said, yeah, I got a lot of problems with these. Yeah.
I bet.
Yeah. Yeah.
Yeah.
All right. Anything else I should know before I sentence on this file?
Your Honor, like I said, he's a hardworking guy. He knows my office well. He's going to move forward in the right way. So we would ask you to take some consideration of that.
All right. So we've got some old files we owe money on. It looks like $860. Part of that was the case I just kicked out. That was 170. Are you in a position to get some kind of payment set up on a regular basis, weekly, bi-weekly, monthly? Can you get some payment schedule set up on a regular basis?
Yes.
Can you commit to that today? Okay, do that before you get out of my building. All right, so on today's file, fines and costs are $500. I'm ordering 4 days on the court work program. Work program is assessed as an alternative to jail. I would suggest you go down and find out the quickest you can schedule them, because you're either going to work for me during the cold weather or you for the cold weather. So let's get these banged out so when you get a job that actually pays you, you can get it done. Any questions?
And they offer much weekends.
We don't, weekends are tough for us.
Okay.
We're trying to gear up with more weekends, but right now, do the weekdays.
Gotcha.
But while you're not working, yeah, because we're not going to kill you out there. You're not going to work as hard for us out in this weather than you would for you. So with the money you already owe on the old stuff and the 500 day, go down and set up your payment plan.
Will do, Your Honor.
All right. Good luck with your license when you get there.
Thank you. Judge,
Always a pleasure.
off the record, our friend John, helping him with something else. He's doing well.
Good.
Brought a Christmas basket for my daughter.
Always. Yeah. He's a sweet guy.
Take care.
Say hello to your big boss.
Well,
Caitlin Langley. Miss Langley, are you going forward today without benefit of an attorney? You've met with the prosecutor. Says here that you're going to plead responsible to a double parking civil infraction. You've agreed to pay fines at cost of $150, and the prosecutor wants me to dismiss the misdemeanor. That's all true? True? All true? True. That's correct and true both. Okay. Can you pay the $150 today? By 3? Okay. Questions? Good to go. Enjoy your day. Like Rod, you're going forward today without benefit of an attorney?
yes, sir.
Double parking for you?
Yes, sir.
Fine the cost 300?
Yes, sir.
And that's the way you want to resolve this today?
Yes, sir.
All right, I'll dismiss both charges from December 19th. Can you pay the 3 today? No. I'll give you a due date.
Yeah.
Look at the calendar. Tell me how long you need to pay 300. The reason is because all this is on hold until we get your money. Then we put it through to match the deal.
Yes, sir.
You looking for a due date? You can walk over there if your eyes aren't any good. Yeah. So
February 6th.
February 6th, what day is that? Yep, I like Friday due dates. All right, any questions? Good to go. Stay warm. Meredith Allen. Good morning, ma'am. Are you going forward today without benefit of an attorney?
Yes.
And you've met with the prosecutor. You've agreed to plead responsible to a third charge, double parking. You've agreed to pay fines at cost of $500. Wonderful. I will dismiss the original charges from November 23rd. Can you pay the fine today? Go down. You're probably going to be the first in line, so you'll get a big smile from the cashier. Have a great day. You're welcome. Yep.
That's on, B
Yep.
and at 500.
Yep. Good morning, Mr. Young.
Where's your honor?
Studio.
Dean, is it Crumpton? Come on up, sir. Mr. Crumpton, are you going forward today without benefit of an attorney? Let's see what you did. You made a deal with the prosecutor? Oh, all right, you're requesting an adjournment. Okay. March,
I think you want to talk about.
yeah, March 12, 8 a.m.
Yes, whatever I have on. Yep. Yep.
You can get started. All right, Mr. Crumpton, we've got two files. You've got bond money on both. You've got a civil infraction, which is a speeding ticket. That bond is $300. You've got a misdemeanor, drove while license suspended, revoked, or denied. That bond is $500. If we switch your bonds, that'll give us enough money to pay off the civil infraction. You're done with it. Is that all right with you? Okay. Actually, probably the way to do it is just, yeah, and then whatever's left, put it on.
I'll get
Yeah.
the bond on the other one.
All right. So have a seat. We're going to get you a paper notice for that new date. Questions? You're good to go. After you get your notice. Kenya, is it Tatey? Teet, one syllable. Come on up. As if it was T-E-E-T. Gotcha. All right. You're going forward today without an attorney, correct? All right. I got paperwork here, so you made a deal. All right, you're going to plead responsible to double parking. Prosecutor wants me to dismiss both charges from January 2nd, and you've agreed to pay $300, right? Can you do it today?
No.
Are you working? Where do you work? Mako? Mako. What do they do? All right, where are they at? Okay, how long you been there? Full time? Good. All right, so you owe some money on some other stuff too. Violation of permit, equipment violation. Oh, that's what these are. Yeah. You got to fail to display valid license 2 times. You got one from 23, one from 24. Almost $1,000. So are you in a... Great, but you still owe the money. Yeah. So are you in a position to commit to some payments? Weekly, bi-weekly, monthly, what works? All right. How much can you do and when can you start? No. 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 If you're working full time.
That's a lot. Like 3,000. I can start paying the fees
Can you do 50 a month? Starting soon?
by February.
Pick a date. 10th? Yeah, we'll always take extra money. But if this way, at least we got you nibbling away at it. All right, so you need to go downstairs and get that on paper before you get out of here. So just go to the front counter and tell them you're setting up a payment plan. Yep. Yep. All right, so that 300 plus what you already owe us, that's one big payment plan. All right, good luck. Good luck with the truck. William Burrell. Burrell or Burrell? Mr. Burrell, you're going forward without an attorney, yes? You've made an agreement with the prosecutor, correct? You're gonna pay $300 on the double parking and the other two get dismissed, right? All right, that's two charges from 12/12/25. Can you pay the three today? When? Due date over there, if you can see the calendar. If you can't, take a walk. 10? 30 days? Yeah, we can do that. Any questions? All right, you can remember that? You don't need a piece of paper from us? All right. Did you hear what I said? If the money doesn't get paid when it was supposed to, then these are back up and you got to deal with them. Gotcha. Yeah, you should be. It's a good deal. Have a good day. You're welcome.
Yes, this is drive, they were driving. It's not a working.
Yes, Hardaway. Miss Hardaway, are you going forward today without benefit of an attorney? Okay, so you're pleading responsible to impeding traffic and the misdemeanor charge from 12/31 is dismissed. That's the deal? Okay, impeding traffic is $180. Can you take care of that today? Go downstairs and get your smile and get on your way. You're welcome. Enjoy your day. Morning, Council. Is it Hamadi? Come on up. Sir, are you going forward today without an attorney? Yes, sir. All right, so you made a deal to plead responsible to double parking and receive 2 dismissals from January 1, correct? And you've agreed to pay fines and costs of $300? Can you pay that today? Go downstairs and get a smile. We'll get you on your way as soon as we can. You're welcome. Enjoy your day. I'm out of files.
What's your name? It's really good. It's
The other ones are waiting on attorney, Judge, this, I saw it here, we've been waiting on it. Did you talk to your attorney? Yes. Okay.
What's the name?
Last the block, BLOCK.
How you doing?
Good.
You're one of our blocks.
Excuse me?
You're one of our blocks. Your local block.
Yes.
Yeah, you look like all the blocks. Who's your dad?
Looks like Freddie.
I'm a little hard to hear.
Just.
Who's your father?
My father's over clock,
Sure,
Freddie Block.
sure, sure. Yeah. All right. So, all right. So I'm going to arraign you today and then we're going to get you a date. Who's your attorney? Oh, Murray. All right. You talked to Murray about this? Set for a pretrial. You just bump it out, and if Murray doesn't like the date, he'll call you.
Prior, I've had numerous conversations. This case was originally before Judge Martin. The state toxicologist individual could not make the jury trial, so he dismissed and refiled. So he has everything that he needs.
Okay.
Else I'll get it to him.
Thanks. All right. So you understand your rights?
Excuse me?
You understand the rights you have?
Yes,
You understand the options those rights give you?
yes.
You understand the possible penalty for the charge? I'm going to enter a not guilty plea for you and get you a court date.
Yes.
I'm also going to set your bond.
Yep, Judge, that's 50. Okay.
They didn't like 50?
No. You approved it, so they'll take it.
You got a date yet for this one, Mr. Brock?
We can do 2/26 at 8:30.
February 26th, 8:30 in the morning?
Yes.
All right, I'm gonna put you on a personal bond. 3 conditions. Number 1, stay out of trouble. Number 2, show up for court. Number 3, do not purchase, possess, or consume any alcoholic beverages or marijuana unless you got a doctor's script, and you ain't getting a script for those. Understood? Any questions? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you screw that up? You mess up on bond, we put you in jail, you gotta have $1,000 or more to get out. Questions? Any questions?
No.
Have a seat until we get your notice. You want to scratch some names?
Sure,
I didn't,
no problem.
I didn't get blocked.
Last name of Mauricio and then,
Mauricio with an M?
yep, Mericio.
Okay.
And the other one is up, down on the water, I can't. Oh, wow. Okay. See if I can put down here. DeLauder. Ethan DeLauder, DELAW.
Yep. Which one you want to start with?
Start with Mr. Delauder is just observing. We have selected, March 12th at 8:30.
All right, well, you don't need me for that then.
Correct.
All right, Mr. DeLauder, we'll get you a paper notice in a minute.
Then we would have Mr. Mauricio.
Mauricio? Go ahead, Mr. Brown.
Jerry Box, appearing on behalf of Mr. Mauricio. Sir, could you tell the judge your name and the record?
Good morning.
Your Honor, today's date time for arraignment in this matter was agreed. We've also had a chance to treat this case, Your Honor. I've spoken with the prosecutor. I've spoken with Mr. Mauricio. At this time, Mr. Mauricio will be pleading guilty to the charge of.
Can you get a hold of Caitlin?
Or
On this case, I want to know if she's got a victim. Do we have to send a letter out? Does she have any input for sentencing?
I don't think there's a victim, Your Honor. It's a mutual friend.
Miss Foley Carter on Mauricio, any input before I sentence today?
None, Your Honor.
Okay, do me a favor, just crank that 5. I got it. The first person that talks to me, I'm just gonna crank it up. It always turns itself down. All right, Mr. Bowditch, you've discussed your rights with Mr. Bowditch. You understand those? You understand the options presented? You understand the possible penalty for the charge? Understanding all that, are you pleading guilty freely and voluntarily? Mr. Bowditch, would you voir dire for a 12/18/25 incident date?
Yes, Your Honor. Mr. Mauricio, on December 15th of 25, you're on township.
Yes, sir.
Did you respond to an accident on that day that your wife was in?
Yes, sir.
Did you and the driver of the other vehicle who was at fault get into an altercation on that day?
Yes, sir.
Was there a fight?
Yes, sir.
That's satisfying, Your Honor.
Thank you. I'll accept the plea. What should I know about Mr. Mauricio?
Your Honor, other than the fact that he just lost his temper, the young man crashed a red light, tore the whole front end off his wife's car when he got there. His wife was all strapped up.
How's she doing?
She's here with me, we're going to physical therapy and, she got to go for an MRI. She got dizziness.
Good luck.
He just, they confronted each other and there was a fight.
Yes, sir.
You're too old for that.
It was also in front of a police officer.
Yes. I am too old for this.
I understand you were freaked, you thought all the bad things, right? But are you working?
Actually, I'm retired. I do, work, here and there through, Holy Redeemer Church in Detroit.
Okay. Anything else you want me to consider before I sentence you?
If I could I do community service if possible at my church?
Nope. I'm gonna have you do work program. Different issue. All right, Mr. Mauricio finds it costs $500 and I'm ordering 3 days on the court work program as an alternative to jail. Can you pay the 500 today? All right, go downstairs and schedule your 3 days. Good luck. Good luck, ma'am. Bruce Jones. Mr. Jones, are you going forward today without benefit of an attorney? You made a deal with the prosecutor? Bless you. You made a deal with the prosecutor? You've agreed to pay $300 on a double parking civil infraction and will dismiss the misdemeanor from April 22, 23. Is that the deal? Can you pay the $300 today? February 7th? Done. Understand if that doesn't get paid, then this misdemeanor doesn't go away. Any questions? Have a lovely day. Thanks. Thank you. Arthur Evans.
Arthur Evans, today's arraignment pre-trial, formal reading to waive. Ask the court to enter plea of not guilty for arraignment purposes.
Done.
Your Honor, we have pre-tried this matter, the brief prosecutor, whereby the pending charge of the operating while intoxicated would be dismissed. My client would be tendering a guilty plea to the reduced charge of operating while visibly impaired.
Thank you. Mr. Evans, have you discussed your rights and options with Mr. Hadley? You understand all that good information? You understand the possible penalty for the charge? Understanding all of that, are you pleading guilty to the added charge freely and voluntarily today? Mr. Hadley, if you would voir dire, December 4, 2025.
On December 4th of 2025, were you operating ship, which is in the county of Wayne, state of Michigan? Okay. And on that night and time, were you involved in a single accident or a single vehicle accident involved yourself or other involved people? Just my issues. Okay. You were driving the vehicle. Okay. And police did respond to that? Yes. Okay. In fact, you called the police? Yes. Okay. And had you ingested alcohol before driving the car that night and encountering police? Yes. And did the alcohol impact your ability to drive? Yes. Okay. Your Honor, I do feel the elements have been satisfied.
So do I.
Threw a little bit of allocution in there again. Not that it does negates what happened, but it shows that my client recognized immediately. You know, he walked out of the accident. He wasn't calling for medical attention. He knew that it was what he'd done was wrong.
Right.
For lack of a better way to say it. He's no prior criminal history.
Good.
So it doesn't negate how serious this was and how serious it could have been. He was very candid with me today, talking about the I don't even know, waking up with holy kids could have lost me, you know. So I just tell the court all that to say that I think he's going to be completely compliant between now and sentencing. We would just ask the court right now, financially, things are a little bit tight. If there's going to be any testing requirements between now and sentencing,
There won't.
just so that was my only concern. Financially, he's kind of bracing for what.
Yeah. Responsible.
Sir.
Okay. So first of all, I'll accept your plea to the added charge. I'll dismiss the original charge. I'm going to send you downstairs to the probation department. You're going to schedule to come back for an interview, and they'll also tell you when you're going to be back for sentencing. All right. So the way that works is based on the interview. Have you gone over all this with him?
We did.
All right.
Yes,
So you understand how the process works from this point forward. Okay. So in the meantime, I'm going to put you on a personal bond. First two conditions are pretty obvious. You stay out of trouble and you show up for probation and sentencing. Other than that, don't purchase, possess, or consume any mood-altering substances unless you've got a doctor's script. That means no alcohol, no marijuana. Can you live with those rules? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you mess that up? You screw up, we put you in jail. It costs you money to get out. Any questions? You're all set. Go downstairs. Oh, you also owe us some money on civil infractions out of the same incident.
Same incident?
Yeah, no proof of insurance and equipment violation. Why don't you come up with a really interesting, never heard before argument why I should set those aside and dismiss them at the day of sentencing? You better wow me.
Just cooperative probation. Thank you, Your Honor.
You're welcome. You folks are all waiting for your attorneys?
What we wait on Mr. Bowden.
For arrange, are these adjournments?
Oh, adjournments, okay.
Thomas in German.
Only one of them was a German.
Where's the Thomas party? What's your last name, man? Was he your German?
Yeah, I was the other form. I needed the double parking.
Yvonne Smith, your judge, gave you the.
Oh, sorry. Miss Smith, come on up. You know why? I'm ahead on the paper.
Miss Smith, just state your name for the record.
Yvonne Smith.
Good morning.
So, Your Honor, we're here on the show cause. Miss Smith and I cleared up, I think, what the confusion was that she had almost at the same time. There was a Van Buren Township case that we've talked about. She squared away. So, yeah, it was not an intentional situation. And it actually, in fact, resulted in a default of about $480 in tickets that had she shown up, probably would have been able to work something out. So we would ask for, I don't think a warrant's been issued on this one. Right, Heather? I think it was just a show cause. I guess we're asking for any warrants to be recalled if any warrants.
No, I don't think there's any warrants.
Phenomenal.
And that was the piece of paper I was looking at for the other guy. I thought he had defaulted civil infractions.
There
So
we go.
you're okay. All right. So I'm going to dismiss the misdemeanor from November 23. You're going to plead responsible to double parking, correct?
Yes.
And you've agreed to pay $300?
Yes.
When?
I thought it was two.
Oh, that might be a 2. Okay. When are you going to pay that? The 6th, February 6th,
So it's from tomorrow.
There we go.
February 6th. Okay. You're all set.
Thank you.
You're welcome.
And then Thomas, they're giving us the new hearing date, so we're good. What was this?
That's.
I used to call my letterhead sitting on a random.
That's, prosecution.
Did Rob tell you you canceled the interpreter on the South Side?
Yep.
Yes.
That paperwork, so I can do that. Whenever we are.
Love it when a plan comes together.
On the west side of
Favorite. Just hands that would be very rare for you.
This one is the arranged. Judge, this is a different one, but it just needs to be arranged because it's a drunk drive.
This honorable court in the office of the public defender, hopefully do not believe that any such conflict exists. We make this waiver the avoidance of all doubt.
Thank you.
Your Honor, Jody Gaines, Senior Assistant Public Defender. We too do not believe that there is a conflict, but if there is any conflict, we would waive it as well.
Right, thank you. The court also does not believe there's a conflict either, and in Michigan court rules, other cases decided there under to the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the case of the people of the state of Michigan versus Sandra Law.
Alex Jamalowski, the people.
Stephanie Can on behalf of Ms. Law. I will let him know. Your Honor,
State your name, please.
Sandra Law.
All right, where do we go?
Ms. Law has elected to waive her right to a preliminary exam. Your Honor, my client is outside of counsel's advice, asking to speak to the court, and she's also asking to have her daughter be allowed to speak to the court. I've informed her that her daughter will likely not be able to speak to the court because that is inappropriate, but she wanted me to ask.
All right, well, you can do the way, I don't know what you want to address to the court.
Can I read something to you, please? Your Honor, do you want to address the waiver first? How do you want to proceed?
You want to do the order? What is that, Ms. Cannon? No. If you want to do the waiver, we can, that's fine. Ma'am, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
Understand that you'll not have that hearing. You'll proceed to circuit court for further, bless you. You'll proceed to circuit court for further proceedings.
Yes.
All right. People also waive their right.
Yes.
Preliminary examination having been waived, found over to circuit court on count 1 with 2 following.
Your Honor, we would waive formal reading of the information, stand mute, and we're asking for our next pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
February 2nd at 1:30 before judgment.
February 2nd, 2026, 1:30. Judge will move.
Can I read something to you, Your Honor?
As long as it's not too long, go ahead.
It's not. I apologize to you and your court for my situation of my stinking thinking attitude to allow my relapse and my time of sorrow. I've been caught in addiction for 15 years. Before this relapse, I have been sober for over a year. As of now, I have been incarcerated for 78 days, waiting for a plea deal to be sent to treatment. So far, there has been no eval. I was set to leave for treatment on a tether to Oakdale twice and subsequently been let down both times. There was a delay in my relapse due to bond differences in between both cases. I was not present for my Medicare renewal, so it has canceled. I'm concerned about me not being eligible to pay or have insurance pay for my long-term treatment. I worked hard in my sobriety to have a productive life. I went from having nothing in my life but a pipe and a rock to having things that make my life of importance: a job, schooling, a home, surrounded by my family, pets. I accumulated all that back. I write this to your court today to ask that I be released today to go back to my productive lifestyle that I struggled for. I have an awesome support system, a sponsor. I will continue outpatient treatment, drug testing, and my sobriety. I want a chance to show to this court I can be a responsible, clean, and sober out of jail. Thank you for your time.
Yes, I'm gonna be real. I've listened to this now 3-4 times. My position has not changed, and it is not going to change regarding this case. I did approve. The last one I approved was January 14th, her release to treatment.
Understood, Your Honor.
And that is what I said I would do every time. I approved it. I don't know what has happened there. Somebody else can look at that. But I'm not changing my position, Ms. Law. You can keep saying the same thing over and over. I'm not going to do anything different.
I understand that, but what has held me back is with the treatment situation. Okay, I was put on a 90-day home arrest tether with Miss Washington's case. And me going to Oakdale, they set me back, they put me on a tether, and I couldn't leave. So my case with her is up, and I did my time in jail with her. It'd be Monday. So that's what set me back from treatment. And I have an eviction on my home that you did. I have to be out April 1st. So it's like I'm facing an eviction that I can't get
I've
my
heard all
possessions
of
out.
this, Ms. Law.
I
I
understand
know this. It's not like I'm operating in the dark. I have heard everything that you are telling me now 2, 3, 4 times.
I understand that, and I don't understand why I don't deserve a chance to do outpatient treatment and get my life back on track over one relapse. I mean,
Did you hear me?
Yes.
I approved outpatient treatment for you.
You didn't improve outpatient, you improved inpatient.
You want to see the form? I
Okay.
signed it January 14th. I'm done. Bond continued.
Thank you.
Bye.
Thank you, Your Honor.
Goodbye.
I don't understand. I don't get it.
That was one case. One case.
Great start, Your Honor.
No, and you were involved, Cam. Thank you. Court calls the case, People versus Avion Johnson.
Morning, Your Honor. Chief Assistant Prosecutor Victoria Burton here to appear on behalf of the people.
You were not supposed to let all that happen to me. Never mind.
Your Honor, I'm so sorry.
Good morning.
Good morning, Your Honor. Edward Drugas on behalf of Avion Johnson.
And Mr. Johnson, can you unmute and state your name, please, sir?
Good afternoon. Well, good morning. Avion Johnson.
Good morning, sir. All right, what are we doing?
Your Honor, I'm asking for an adjournment. We are downloading videos and we need some more time.
More time.
So
what am I doing? Fifth, I gotta skip that one. Fifth, 12th. How long are you intending on being in Oakland? How long are you gonna be in Oakland County Jail? Do you know?
To May.
He's till May.
Till May, all right. Probable cause conference will be adjourned to February 12th, 2026, 9 a.m. Bond continued.
Thank you.
Yeah. Court calls the case of the People versus James Kimbrough.
Chief Assistant Prosecutor Victoria Burton here is appearing on behalf of the people.
Edward Drugas on behalf of James Kimbrough.
James Kimbrough. All right.
Your Honor, we're just needing a brief adjournment. This case is going to be annihilated.
And I'll adjourn this to the 5th. February 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Calls case People versus Marcus Claiborne.
Morning,
Morning, Your Honor. Sam Bernstein for Marcus Claiborne. Mr. Claiborne, could you please state your name for the court?
Marcus Claiborne. Thank you.
Your Honor, we're asking for an adjournment to obtain a review discovery.
All right. Is he being held on anything else other than this?
Just this, I believe, Your Honor.
Probable cause conference, February 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus David Gilbert.
Carolyn Foster Tucker on behalf of David Gilbert. He is on Zoom? No. Your Honor, is he on Zoom? No, he's not on Zoom. I have no explanation for his absence. For the record, I'd ask for an adjournment.
Then what were you looking at the door? Never mind. Bench warrant will issue for defendant's failure to appear. Bond is set amount of $10,000 cash surety. That warrant will issue immediately. Thank you.
Thank you, Your Honor.
Court calls case People versus Joseph Bonville.
Your Honor.
Brandon Bird on behalf of Joseph Fonville. Mr. Fonville, can you please state your full name for the record?
Joseph Fonville.
Thank you. All right, you're requesting an adjournment.
I'm correct, Your Honor.
All right, this is the only thing he's held on.
I believe, is this the only thing?
Yeah.
I believe so.
Yeah.
All right.
Probable cause conference then will be February 5th, 2026, 9 a.m. Bond continued.
Just permission to address bond, Your Honor.
Go ahead.
Respectfully, my client indicated to us that he does have Medicaid and he's looking to be released to community health. It's not the fact that
to community health,
mental health.
Yeah.
He's looking for some sort of mental health treatment. It's not the fact that he can't afford bond. He could have been posted bond if he wanted to, but actually, and he has a place to stay. So it's not like he's using the jail as housing either. But he's been trying to make sure he stays out of trouble. but he really wants to address some mental issues, and he just asking his court, can he please be released to mental health?
I'm not gonna have an issue with that necessarily. I mean, he's got $1,000, 10% bond, I think it is on this case. So, I mean, it's not like we're really holding him. If you prepare an order, I'm sure the jail will use their resources to try to see something that will, see if there's something available for him.
Thank you,
All right, thank you. So at this point, his bond will continue.
Thank you, sir. Any honorable court, have a great day.
You did, are you done?
Done.
I should make you stay.
As long as you buying lunch.
Court calls the case, People versus Marissa Dix.
Good morning, Your Honor. Robert Ellman on behalf of Ms. Dix, who should be present over Zoom.
Good morning, Your Honor.
Good morning. State your name, please.
Marissa Dix.
Okay. I have before me a plea form that indicates that the defendant would be pleading to a count, doesn't say kind of plea. I'm presuming since I read the police report, it's a no contest.
That's correct, Your Honor. My apologies.
No contest plea to count 3 of stalking, the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. Defendant is also agreeing to complete full 5 years probation with no early discharge. Not object to any personal protection order extension by the victim, participate in mental health treatment, complete a substance abuse assessment, and follow all recommendations from that assessment. That is what the defendant is agreeing to do. The prosecutor and defendant agree that the prosecutor will recommend that a current PPO violation will be dismissed. That's the court's full understanding of it.
The defense understanding as well.
Dix, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for the record.
Marissa Dix.
All right, you can put your hand down. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge, or pleading no contest to the charge of stalking. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine, and up to 5 years probation. You understand that?
Yes, I do.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right. 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes.
All right. Do you still wish to plead no contest?
Yes.
Basis for no contest plea?
Potential civil liability.
All right. To the charge of stalking, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
You had executed or caused to be executed in advice of rights form?
I'm sorry, what was that?
You caused to be executed in advice of rights form, meaning you went through it with your attorney and your attorney signed with permission, or you signed off on an advice of rights form?
Yes, I did.
All right. Do you have any question regarding any of those rights?
No, I do not.
All right. With particular attention to paragraph 5, which are your trial rights, you understand that you're waiving or giving up all of those rights?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
Not currently. Not yet.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes.
All right. court has been provided and has reviewed two police reports. Both Ann Arbor Police Department reports for cases for their case numbers 25-51811 and also for 25-40451. Any objections to the court having reviewed those reports?
No, Your Honor.
Based upon the review of those reports, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ms. Dix, I do have to inform you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
People are not, Your Honor.
No, Your Honor.
And have I complied with the court?
Defense is satisfied.
Court will accept the defendant's no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
February 18th at 9 a.m. before Judge Perry.
said 18th.
Yes.
February 18th, 2026, 8:30 before Judge Perry. 9 a.m. before Judge Perry, excuse me.
Thank you.
Bond will continue. Thank you. Thank you, Ms. Dix.
Thank you, Your Honor.
May I-
Have a good day.
May I address Bond shortly? She still has a GPS tether on now that the charge has been reduced. Is there any chance of removal of the tether prior to sentencing?
I am not going to remove it.
Fair enough, Your Honor. Thank you.
Okay.
Thank you.
I like that kind of bond motion. Thank you, Mr. Elman. Court does call the case of People versus Seth Pronick.
Morning, Your Honor. You cannot pretty bad people.
Morning, Your Honor. Chris Eastup appearing on behalf and with Seth Kroenig.
Your name, sir?
Seth Kroenig, Your Honor.
All right.
Your Honor, today, my client understands he has a right to a preliminary exam. He's knowingly going to waive his right and be bound over the circuit.
Is that a correct statement, sir?
Yes, Your Honor.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause the offenses alleged were committed.
Yes, Your Honor.
And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yeah.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following. Mr. Eastup.
Your Honor, waive formal reading, stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to both counts. Pretrial will be set for
February 4th at 1:30 before Judge McNally.
February 4th, 2026, 1:30, Judge Conley. Bond continued. Let's call the cases of the People versus Kimberly Douglas. 2 cases.
Top 10 last with the people.
This is Mr. Gaddy. Oh, there you go.
Mike Gaddy, Assistant Public Defender on behalf of Ms. Douglas, who is here via Zoom, Judge.
All right, Ms. Douglas, can you state your name for me?
Kimberly Sue Douglas.
Your Honor, I'm requesting a brief adjournment of this matter. The people have made an offer. It was after I visited Ms. Douglas yesterday, and she's not able to appear here today, so I couldn't see her in lockup about it.
Yeah. Is this the only case holding her? Yes.
I do not believe so, Judge.
All right, gotcha. All right, probable cause then will be adjourned February 5th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continue.
I'll come visit you, Ms. Douglas.
Thank you.
Court does call the cases of the People versus Giovanni.
Top 10 last with the people.
Assistant Public Defender Jay Bellinger, on behalf of Mr. Moot, Your Honor, on cases not ending in 1665.
Gotcha.
Good morning, Your Honor. James Belsky appearing on behalf of Mr. Moot on the case 1665.
All right.
And Your Honor,
Your name, sir?
Giovanni Moot.
Thank you.
Your Honor, we are just seeking an adjournment. We have an ongoing investigation that should hopefully be wrapped up in the next couple of weeks.
And I'm also waiting on some electronic video discovery, Your Honor.
And we have, I have confirmation that that was sent via mail yesterday, so he should be receiving that soon.
All right. So 5th or the 12th, which would you prefer?
I'd prefer the 12th. I have a conflict on the 5th.
I would defer to Mr. Pipelski.
Probable cause conference, February 12th, 2026.
That'll give us more time.
9 a.m. bond continued.
Thank you, Your Honor.
Court does call the case of People versus Kylie Burton.
James Pifelsky on behalf of Mr. Burton, who is approaching. State your name, please.
Kylie Burton.
Your Honor, this is the first PCC I'm asking for an adjournment for, to receive and review discovery with my client.
February 12th, 2026, 9 a.m. Bond continued.
Thank you very much, Your Honor.
Thank you. Court calls the cases of the People versus Kawanda K. Thomas.
Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
Stephanie Cannon, on behalf of Ms. Thomas, as it relates to the matters ending in 1945 and 5565.
And Sherilyn Foster Tucker on behalf of Ms. Thomas in the matters ending in 5653 and 1211.
All right. You gotta give them space. Your name, ma'am?
Hello, I'm Kiwana Quay, Cynthia Rose Thomas.
And Your Honor, we're asking for adjournment. We are attempting to seek a global resolution for the matters that she has outstanding. And our office has been in contact with the prosecutor regarding that, so hopefully we'll have some sort of resolution soon.
All right.
That's not a problem.
How much time are you gonna need to try to wrap all of these up?
It's a lot of information for the prosecutor to.
Are you saying they're slow? You're saying they're slow and can't pick up the information? What are you saying?
No, it's a lot to
Oh,
go
okay.
over and come to a resolution.
I didn't know what you
But
were
we
saying.
have the big dogs now, Your Honor, so
Wow.
you're not. Things don't happen.
My staff make things happen every single day.
Her staff is phenomenal.
Okay, now that we've gotten done with the pat on the back, how much time do we need? Pardon?
And at which point I do believe my client will be in treatment by then, so.
Okay. Probable cause conference, February 19th, 2026, 9 a.m. Bond continued. Court calls case of People versus Cynthia, is it Dupless? Okay. I'm forgetting an S in there somewhere, but. Come on up, man. We don't, this is a public defender case, but I don't know who's assigned.
Rob Down, Assistant Prosecuting Attorney, on behalf of the.
Reese here.
Yeah, the substitution is being emailed to me.
Substitution. Okay.
Oh, the subs,
The substitution,
right now.
Yeah.
Okay, go ahead.
Good morning, Your Honor. Jordan Goldberg, PA 7047. I'm standing in for newly substituted counsel Nicholas Somberg on behalf of Ms. Duplessis.
You have no objection to that, ma'am?
No.
All right. What are we doing?
Your Honor, we would ask that you set it for an exam. I have Mr. Somberg's calendar.
Is all discovery complete?
He has received discovery. He is still reviewing it, but he is ready to go for an exam.
I understand what you're saying to me. My question is all discovery complete?
I believe so, Your Honor.
People have their witnesses available the 3rd.
Your Honor, I'm actually in trial that week with Judge Mood.
Any objection to going beyond that date, counsel?
No, Your Honor, we would waive 21 days.
The 10th? Will that work for the people?
Yes.
Yes, Your Honor.
Preliminary examination in person, February 10th, 2026, 9 AM. That's before Judge Freshow.
And I do have one bond issue I'd like to address.
Go ahead.
Your Honor, my client has no felony criminal history. I understand the charges in this case are serious. She has been ordered not to have contact, obviously, with either complaining witness, but she's also ordered not to have contact with children of any kind. She's been ordered not to return to her own house, where one of the complaining witnesses previously resided and no longer resides. As a result, she's been living out of her car. She's been driving 2 hours from Clinton to Adrian to work every day. Your Honor, I'd be asked that you modify bond to permit her to have supervised time with her 3 children separate from the complaining witness in this case, and also return to her home in Clinton. Her husband, who is the father of her 3 children, separate and completely unrelated to this case, is present. He would be present for any supervised time with the children, who again are not complaining witnesses in this case. I believe the bond condition that she not have contact with any of her children at all is overbroad and unreasonable.
Your Honor, I was at the arraignment. It was supervised visit to be supervised by Lenawee County CPS.
That's already been ordered.
Yeah.
That's what I see.
Then the only outstanding matter would be permitting her to return to her home. It was previously listed as the home of one of the complaining witnesses. None of them stay there anymore. The people who live there are her 3 children and her husband, her 3 children who are not related.
Who is Khalil Harvey?
I believe that is
That is one of the.
I know, but who is that to this defendant?
An ex and a child of her father. He is one of the complaining witnesses.
She indicated in the arraignment that she was living on Carriage Avenue in Canton, Michigan. Is that not true?
That's where I had to stay.
I believe that's where she was sleeping during the arraignment, but that has since changed.
I don't think the victim or the child is in Clinton, so I don't have an objection.
They what?
They're not in Clinton. The address in Clinton. They're with the father, the other 2 children who are not involved in the case.
I don't have, that's not the prohibited address I have in Clinton.
How about this?
I have a prohibited address of Ann Arbor, on Ann Arbor Trail. And then Post Oak Drive, okay, that one I see. Post Oak Drive, they didn't list the town. So those are the 2 that I have.
Right. If we could do a stipulation if you want.
I think you need to, because I don't know what
We're asking she be allowed to return to Post Oak Drive.
I understand what you said, but you're not giving me all of the information regarding who's there, who's not there.
Yeah, I can put it in a written motion if that's preferable.
Why don't you try this? Call Mr. Talk to him and then see if you can stipulate. If you can't stipulate, then I'll be happy to hear your motion.
Happy to do that, Your Honor. Thank you so much.
Bond is continued. Motion at this point is denied. Thank you. Court calls the case, People versus Devontae Connor Belcher.
Sherilyn Foster Tucker on behalf of Devontae Connor Belcher.
Your name, sir?
Devontae Connor Belcher.
Thank you. What are we doing?
Judge, there should be an amended complaint.
Yes.
I emailed that to Mr. Bernstein, I informed Ms. Foster Tucker about it. Just a comment.
And then it's gonna be remanded on count 2 down.
Yes.
Yes.
So with that objection, count 1 is dismissed. As to count 2, you waive reading of that and stand mute.
Yes, Your Honor.
And he pleads not guilty to that charge.
That is correct.
Pleads not guilty to count 2. Pre-trial in that matter,
8:30 before Judge Perry.
February 11, 2026, 8:30, right? Before Judge Perry. Bond with its conditions.
Thank you.
Thank you.
Have a good day, Your Honor.
You do the same. Court calls the case People versus Jala. Is it Jala Allen?
When you're reading to the people.
Assistant Public Defender with and on behalf of Ms. Allen. Would you please? Shayla Allen. Okay.
Okay, I was gonna try that first and I said, nah. Anyway, go ahead.
Your Honor, we have requested some additional media discovery and are requesting of an adjournment.
Okay, that's fine. Do I have a green sheet? Or
Yes, Your Honor. Well, excuse me.
it's being done?
It is completed. It is right there.
Oh, so it was late? Yes.
Yes.
Don't worry about it. It's okay, it's Miss Gaines. We'll let it slide.
I apologize. I don't know why I was sitting there holding them. I said that to her.
No, it's okay. February 12th, will that work? Or you want the 9th? Or you gonna need more time?
Okay.
12th to work. February 12th, 2026, 9 a.m. bond continued. Thank you. Court calls the case People versus Mary Barney.
Morning, Judge Michael Gaddy, Assistant Public Defender on behalf of Ms. Barney, who's here in the courtroom. If you could state your name, Ms. Barney.
Mary Barney.
Yeah, what do we do?
Your Honor, this is going to be a waiver. I have gone over, Ms. Barney is executing the waiver forms as we speak. The people have agreed not to add any additional charges, Judge.
So she's waiving on both cases.
She is waiving on both cases, Judge.
Ma'am, is that correct?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and you committed them.
Yes, I understand.
You understand that you will not have that hearing? And
Yes.
you'll proceed to circuit court for further resolution.
Yes.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on the case ending in 2206 on all 4 counts. And on the other matter, 1869, counts 1, 2, 3 with 4 following.
That is correct, Your Honor. I have gone over her right to an exam with Ms. Barney, as has the court.
Okay.
In terms of arraignment on the information, we'd waive reading stand mute.
Defendant having waived formal reading standing mute, court will enter a not guilty plea as to all 8 counts. Pre-trial in these matters will be set for February 3rd, 2026, 1:30 before Judge Cuff.
Thank you, Judge.
Thank you. Yes, ma'am, surely. Well, I get it. Sorry, get rid of the information. Court does call the case People versus Amber Lee Almany.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Almany. Your
I have before me a plea form that indicates that she is going to be pleading guilty to the charge of firearms charge of possession on on restricted premises, the 90-day offense. On her successful plea to that charge, count 1 would be dismissed. And there is a sentence agreement. The prosecutor's delayed sentence under 771.1 to dismiss the case upon successful completion of delayed sentence terms set by the court. That's the court's full understanding.
That's the extent of our agreement, Judge.
May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you about to give will be the truth, the whole truth. Help you God.
Yes.
State your name, please.
Amber Almany.
All right, you can put your hand down. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of possession of a firearm in unrestricted premises.
Yes.
Now, that is a misdemeanor, punishable by up to 90 days incarceration on $100 fine plus court costs. I think it also requires forfeiture of the device and mandatory forfeiture of the device or weapon. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo or her successor, likely. I don't know who's going to be handling the dockets, but Judge Garwood in the 15th District Court. You understand that?
Yes.
Okay. Still wish to plead guilty?
Yeah.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form.
I did.
Any question about those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No. No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty. June 28, 2025. Location of 1514 East Hospital Drive, City of Ann Arbor, Washtenaw County, State of Michigan. And I believe that's part of U of M hospital premises. Did you have a weapon in your possession?
I did.
All right. And you were carrying that weapon?
It was in the vehicle. Yeah.
It was in your vehicle? And you understand that you were not, the hospital location is prohibited premises?
Yes.
To do that. You understand that? All right. Ma'am, if I accept your plea, if you, between the time of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, first of all, would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No.
No, Judge.
And have I complied with the court?
Yes.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at district court probation. Sentencing in this matter will be
February 17th at 9 a.m.
February 17th. Mr. Feaster, can you approach on a separate matter, please? February 17th, 2026. What time? For Judge Valvo.
Thank you.
Judge called the case of the People versus John Boyer. 3 cases.
I'll check it out. Excuse me.
Sorry to wake you.
Good morning, Your Honor. Assistant Public Defender Chinazi Kyriakin-Rumi on behalf of Mr. John Boyer. Mr. Boyer, state your name for the record.
John Boyer. Thank you, sir.
Your Honor, we would like to set this matter for preliminary exams.
All 3 of them?
Yes, Judge, all 3 of them.
Discovery is complete in all of these men.
To our knowledge, Your Honor.
And would the people have their witnesses available on the 3rd?
Yes.
Preliminary examination in person will be held February 3rd, 2026, 9 a.m. before Judge Perry in all of these matters.
Thank you, Judge.
Bond will continue. Thank you.
Take care.
Court does call the case People versus Malik. Is it Alcidi?
I'll check last week with people.
Well, here she comes.
Good morning, Your Honor. Ronica Glenn requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon. But she's not in here. Hannah Apple?
Here.
She is. She stepped out for a second.
Oh, there she is. Could have been Miss Apple. I wouldn't have cared. Permission to practice is granted.
Thank you. Your Honor.
Your name, sir?
Malik Said.
Thank you.
Your Honor, in this case, we would like to seek an adjournment.
For what? For what reason?
Just some mitigation information we're doing.
Do I have a green sheet?
You do, yes, we do.
Have you already submitted the information, or you've got to pull it together and then submit it to me?
I think we just got it, Judge. If we can, we have a little extra time to look at maybe the 12th, if possible.
Probable cause conference will be adjourned February 19th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of the People versus David Child.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender representing Mr. Childs.
Your name, sir?
David Childs.
Thank you.
Your Honor, at this time, we are requesting a preliminary exam on both matters. And in addition, Mr. Childs would like for me to address his bond.
Discovery is complete.
That is my understanding.
People had their witnesses available the 3rd. Preliminary examination in person, February 3rd, 2026, 9 a.m. before me in both cases. As the bond.
Your Honor, Mr. Childs is requesting that Your Honor release him, grant him a personal recognizance bond with the same conditions that there are already, with the no contact conditions and the no return to the home. He is stating that he would be able to reside with his father. He is also self-employed. He is a floor installer. Yes, self-employed.
Yeah.
Yes. And he also has been working very hard while he's been in the jail to be able to show that he's made good use of this time. During these few weeks that he's been in, a little over a month, he's completed critical thinking for the future CBT. Bill Nye teaches science and problem solving, learn your strengths from the shining light, all-star mastermind facilitator pro, job seeking with a criminal record, anger management, criminal process, the basics. And he has also started.
I understand all of that, Ms. Gaines. I also understand what he's charged with. 2 counts of domestic violence with somebody that is knowingly pregnant at the time. Both are third offenses for.
She's not pregnant.
Your Honor, she's
Pardon?
not.
She's not pregnant. She's had surgery to remove her.
I'm just telling you what.
That is the correct charge, Your Honor. Your Honor, he also has a history of in 2023.
Yes.
He has a domestic violence conviction and purchasing a firearm without a license conviction. Another 2003, another domestic violence. He has a history of at least one alcohol conviction in the past as well. That, along with the fact that this case, Your Honor, are very concerning, especially the firearm portion of it. We're happy he's doing well. I think he will continue to do well. It sounds like there's a lot of great programming. But also benefit from addressing some of the issues that lead him to abuses in your partners, and I didn't hear anything about that yet, so we're glad to do well. On it. I believe that kind of cases would potentially be available to start in as well if he's interested in that.
Yeah, could I have just one? No, thank you.
I'm going to deny the request for any change in bond at this time. Certainly, after the preliminary examination, you can raise those issues, but at this time, it's more for bond reduction. Thank you. Court calls the case of the People versus Walter Peterson.
Morning, Your Honor. Raymond Cook for the People. Good morning, Your Honor. Robert Ellman, on behalf of Mr. Peterson.
Peterson, can you state your name, please, sir?
Yes, Walter Peterson.
Thank you.
And Your Honor, I believe Mr. Peterson has multiple cases up today. I'm representing him in case ending in 02.
Gotcha.
Do you have 1843?
I do.
Ron Brown appearing on behalf of Mr. Peterson in 1843.
What are we doing? You're both requesting an adjournment?
Yes, Your Honor. I was newly appointed. I need time for discovery.
And I submitted the green paper.
Are these the only things holding him, or is there other stuff?
He does have other open pending cases. And it's not with your honor. Bond on that one says that that was 10%. Unfortunately, my actually is not loading, so I don't know if he has any out of.
Your Honor, that was, we were up yesterday on that Sullivan battery.
Yeah. Yep. I remember. I'll adjourn this then to the 12th without objection. Probable cause conference. When did we set his next date before me? Do you know?
You were using the 4th. You were
Fourth.
using the
I think
4th,
you did the 4th.
Yes.
So I can set this the 5th or the 12th. Which would you prefer?
We'll do the 5th, Your Honor.
February 5th, 2026, 9 a.m. Bond continue.
Thank you.
Thank you.
You'll be soon.
Talk to you soon, Mr. Peterson. Have a good day, Your Honor. That's it for me today.
All right. Thank you, sir. You do the same. Court calls the case of the People versus Timothy Welch. AG case. Is there only one?
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Here she is. Good morning.
Ron Brown appearing on behalf of Mr. Welch.
Your name, sir?
Timothy Welch.
All right. He's waiving exam.
Yes, Your Honor. You have the form.
Sir? Yeah, I do. Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that at that proceeding, the people would have to show by probable cause that the offense was committed and that you committed it?
Yes, sir. I don't see any.
You understand that that hearing will not happen and you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the single count. Mr. Brown.
Ron Brown appearing on behalf of Mr. Welch. Waive reading stand. You request pretrial in circuit court, earliest date as he's in custody.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
February 2nd, 1:30 before Judge Simpson.
February 2nd, 26, excuse me, 1:30 before Judge Hammoud.
Thank you.
Bond will continue. Thank you. Thank you, Madam Attorney General. Have a great day.
You as well. Thank you.
Court calls the case, People versus Raphael Bell.
Your Honor, Raymond Cook. Ron Brown appearing on behalf of Raphael Bell.
Mr. Bell?
Yeah, I'm here.
Unmute and state your name.
Raphael Bell.
Thank you.
Your Honor, I'm requesting an adjournment. I filled out your green paper.
Probable cause conference will be adjourned to February 12th, 2026, 9 a.m.
Thank you.
Bond continued. Thank you, sir.
Thank you.
The cases of the People versus Amber Carr.
Victoria Burton here, Chief Assistant Prosecutor, again appearing on behalf of the people.
Michael Gaddy, Assistant Public Defender appearing on 21 FB 1575, Judge.
He was right there. Mr. Quinn,
I can step in the hall. Too.
well.
Morning, Judge.
Morning, state your appearance.
Christopher Quinn, P 69483, appearing on behalf of Ms. Carr.
What are we doing in these cases?
I would request an exam date, Judge, on all three matters. I have the discovery.
And Mr. Gaddy, on yours?
I guess we'd request an exam date as well, Judge.
Discovery is complete in these matters?
My case, yes.
Pardon?
In my cases, yes, Judge.
Yes, Judge, as far as I can see.
People have their witnesses available the third.
We will do our best, Your Honor.
Preliminary examination in person will be set February 3rd, 2026, 9 a.m. before Judge Perry.
Thank you, Judge.
Bond will continue in each case. Thank you. Court calls the case of People versus Corliss Higgs.
Al Kavalowski, the people.
Your name, sir?
Corliss Higgs.
All right, I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
Plea form indicates the defendant will be pleading to count 2 attempted possession of a loaded firearm in a motor vehicle to 1 year offense. Upon a successful plea to that charge, count 1 would be dismissed. There is an agreement between the prosecutor and defendant that the prosecutor will recommend heightened sentencing. That's the court's full understanding of the agreement.
Yes.
Yes, sir. Is that correct, Mr.
Yes, Your Honor.
All right. May I have him sworn?
Right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Corliss. All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted possession of a loaded firearm in a motor vehicle. Yes, sir. That is a misdemeanor punishable by up to 1 year incarceration, fine of up to $1,250 plus mandatory forfeiture of the weapon or device. You understand that? Yes, sir. All right. You understand also, sir, that while you're pleading guilty before me, I would not be your sentencing judge and you would be sentenced in the 15th District Court. Indicates by Judge Valvo, but she's retired, so I'm presuming her assessor or another 15th District Court judge. You understand that? Yes, sir. All right. Still wish to plead guilty? Yes, sir. And to that charge, how do you plead? Guilty. Now, you understand that by pleading guilty, you'll not have a trial of any kind? Yes, sir. You signed an advice of rights form, is that correct? Yes, sir. Any question regarding any of those rights? No, sir. Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form? Yes, sir. You understand you're giving up your right to appeal of right? Yes, sir. Are you on probation or parole? No, sir. Has anybody promised you anything other than what's been stated here today to get you to plead? No, sir. Anybody threaten you or coerce you? No, sir. You're doing this voluntarily? Yes, sir. Of your own free will? Yes, sir. And because you believe that you're indeed guilty of this offense? Yes, sir. On the date of December 23rd, 2024, at the location of 919 South University Avenue, City of Ann Arbor, Washtenaw County, State of Michigan, were you in a motor vehicle? In a motor vehicle? Yes. No, sir.
You were at that location and you went home, correct?
Yes, sir.
And then when you went back to meet with the police, you had with you a bag.
Yes, sir.
And in that bag, there was a gun. Is that correct?
Yes, sir. Okay, so certainly to the higher church. And you did not have authority to carry that weapon in that fashion? No, sir. All right. I think I can. All right, sir, if I accept your plea, You need to understand that if you commit misconduct as defined under the Michigan court rule between the time of my acceptance of your plea and the time of sentencing, that the court would not be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No.
No, Your Honor.
And has the court complied with the court?
Yes, yes, Your Honor.
Court will accept the defendant's plea guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be February 17th, 2026, 9 a.m. We have before Judge Bravo, but you'll have to figure out who that's before. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Man Davis.
Your Honor, Raymond Cook for the people.
Assistant Public Defender Davi Lipa. Well, good morning, Your Honor. Former Mr. Davis. Mr. Davis, can you tell the court your name, sir?
Man Davis. You know, all right. Yeah, I know who he is. All right. What are we doing on this?
And Your Honor, we do have an agreement today
No,
to.
I won't have to.
Okay, now you do. Okay. We'll be setting for preliminary examination, Your Honor.
Discovery is complete.
It is, Your Honor.
People have their witnesses available the 3rd.
We'll do our best, Your Honor.
Preliminary examination in person, February 3rd, 2026, 9 a.m. before me.
Thank you, Your Honor.
Bond will continue.
Yes.
Court does call the case of People versus Wesley Brand.
Public defender representing Mr. Brand.
Your name, sir?
Wesley Brand.
Thank you. You're requesting an adjournment?
Your Honor, at this time, I am not requesting an adjournment. I was able to get information from Ms. Tana that the media discovery, the surveillance video does not exist. Is that right, Ms. Tana?
That's my understanding, is we can just send out, and that's been that information mentioned previously, so that is our understanding, there is no surveillance.
Got it.
But with that,
So that was his understanding of the plea agreement. And we were the one that made the legal responsibility.
That's just background noise. Go ahead.
okay. So with that, we would be requesting the preliminary examination in both matters.
So your discovery is complete now.
That is my understanding.
People have their witnesses available the 3rd. Preliminary examination in these matters will be set in person, February 3rd, 2026, 9 a.m. before Judge Perry. She had that other one. Did we balance this out? All right. Bond will continue. Thank you.
Thank you.
Court calls case of the People versus
Alex Jablowski for the people. Assistant Public Defender Jay Bellinger on behalf of Ms. Ernest, who appears in person, not at the hospital, Your Honor. Can you please state your name for the record?
Adrian Ernest.
Thank you.
And Your Honor, we are just seeking to set this matter for preliminary examination. To our knowledge, discovery is complete.
People have their witnesses available the 3rd.
Yes.
Preliminary examination in person, February 3rd, 2026, 9 a.m. That is before me.
Okay. Got it.
Bond will continue. Thank you.
It's not going.
Court calls the cases of the People versus Bobby Black.
Public Defender Hannah Apple appearing on behalf of Mr. Black, who's approaching now. You state your name for the record.
Bobby Black.
Thank you, sir.
Your Honor, we're asking that these matters be set for preliminary examination.
Discovery is complete.
Yes, to our knowledge, yes, Judge.
People have their witnesses available the 3rd.
We'll do our best, Your Honor.
Preliminary examination in person will be set February 3rd, 2026, 9 a.m. before Judge Perry. Both matters. Bond will continue.
Thank you.
Thank you.
Yes.
Court calls case of the People versus Chidira.
Keji.
Ikiji.
Morning, Your Honor. And Assistant Public Defender Jay Bellinger on behalf of Mr. Ikeji, who approaches. Can you please state your name for the record?
Shadera Bennett, DKG.
And you're requesting a forensic.
Your Honor, we are in line with the other cases, and those cases have been set for March 26th.
All right, I will, forensic evaluations ordered, competency hearing will said March 26th.
Currently, March 26th, yes, Your Honor.
On the other cases, March 26, 2026, 9 a.m. for competency hearing. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case People versus Brandon Boggs.
Assistant Public Defender, Tanabe Carey, I can really on behalf of Mr. Voss, who's approaching.
Your name, sir? Brandon Boggs. Thank you.
Your Honor, we're asking for an adjournment in this matter today. There's some media
Green
that-
sheet.
in my hand, Your Honor.
All right. You're asking for an adjournment.
Yes, Judge.
Purpose of it,
We need to review the information with my client.
probable cause conference will be adjourned February 12th, 2026, 9 a.m. Bond will continue. Thank you. Court does call the case of the People versus Nicholas Meath.
On behalf of Mr.
Nicholas Smith.
Okay, what are we doing?
Set a preliminary examination, please.
Discovery is complete.
As far as I know.
Other witnesses available to the third. Preliminary examination in person, February 3rd, 2026, 9 a.m. That is before me. Bond will continue. Thank you.
Thank you, Your Honor.
House case of the People versus Brian Bussell.
Victoria Burton Harris, Chief Assistant Prosecutor, again appearing on behalf of the people.
Assistant Public Defender, Tanabe Carey, I can really, Your Honor, on behalf of, but unfortunately not with Mr. Brian Bussell.
Who also has a community corrections file.
I am aware, Judge. And we do not have an explanation as to why Mr. Bussell is not present today.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000 cash surety. That warrant will issue immediately.
Thank you.
Thank you.
Thank you.
Court does call the case of the People versus Brandon Myers.
Stephanie Cannon on behalf of Mr. Myers, who is approaching, Your Honor. Mr. Myers, could you please state your name for the court?
Brandon Myers.
And Your Honor, we are in the middle of negotiating this case. My client, we're talking about mental health court. I have the referral form right here. So we're asking for an adjournment of this case to see if he qualifies for mental health court and a couple of other extenuating factors.
Yeah.
Okay. Worried about you, sir. Okay.
Are these the only things holding him at this point?
Yes, Your Honor. Do you have a hold, Mr. Myers?
No, I don't have a hold.
I believe these are the only things holding him, yes.
February 12th, 2026, 9 a.m. Bond will continue.
So I'm gonna come talk to you because you made an offer.
Court calls case People versus Christian Berg.
Senator Davi, leave on behalf of Mr. Byrd. And I did believe he was going to be here today. He did indicate to me that he was checking into treatment. I'm sorry, that she was checking into treatment and that she would still be able to appear. We were going to be requesting a 30-day adjournment for her to complete treatment. Unfortunately, I don't have an explanation for her absence.
Telling me she's in treatment or you don't know?
I don't know for sure. She told me she was going to be checking into treatment, Your Honor.
Oh, okay. Bench warrant will issue for defendant's failure to appear. Bond set in the amount of $10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court does call the case People versus Kent Robinson.
Burton here, Chief Assistant Prosecutor, again appearing on behalf of the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Robinson. Would you please state your name, sir?
Ken Robinson.
Your Honor, we are requesting an adjournment. I just received a police report today. It also would like to address bond.
Probable cause conference will be adjourned. Is this the only thing holding him?
He does have a $100 bond in one other matter that he indicates he would be able to post. So essentially it is.
February 12th, 2026, 9 a.m. As to bond briefly.
Your Honor, Mr. Robinson indicates that he is a lifelong resident of Ypsilanti here in the courtroom present with his girlfriend. Her name is Miss Horn, Jessica Horn, and she is currently expecting. He indicates that he has been employed for 6 years with a landscaping / snow removal company, and he can do that job. He also states that at the time of his arrest, he was picked up on a, at the time of his arrest, he had been, Your Honor, are you looking for why he does not have a bond right now? I can address that as well. Are you looking for why he is being held on this matter?
Well, yeah, I mean, you're asking me to change that, I would presume, because his bond is denied at this point for a violation.
That is correct. And we are prepared to address that. In terms of the violation was the new case that I just spoke of. For that matter, that was involving another young woman that he is no longer involved with. It's my understanding, resides in Ohio, so there's no risk of harm to her. If Your Honor were to put a no contact order, he would continue to reside here in Ypsilanti and would continue to reside with his sister. And he also has the opportunity for employment.
Well, I'm just trying to figure this out. So I have 3 weapons charges that he's before this court on. He's out on bond on that and picks up a domestic violence.
That is
that what I have here?
That is correct in terms of what happened procedurally. He is indicating that he has defenses to that domestic violence matter. And it's my understanding from him that he has not, in his 33 years, not had any domestic violence charges before.
Your response from the people? I don't really need it, but.
I will do my job, even though I can absolutely pick up what the court is putting down.
Okay.
Mr. Robinson was at Ypsilanti Bus Depot, brandishing a firearm as a felon. It was about a 26-minute delay from the time that he was initially seen with the firearm until it was called into dispatch. Law enforcement arrives. He's still present at the bus depot with the firearm. Caused a lot of mayhem and fear. So I absolutely would be opposing any kind of reduction in his bond for that reason. In addition to the fact that he was picking up new charges while dealing with the current charges.
Motion for bond reduction is denied. Bond will continue. Thank you.
And Your Honor, I apologize. I did not hear our next date.
Next date, I set it for February 12th.
Thank you.
Court calls case People versus Clarence Caldwell.
Victoria Burton here, Assistant Prosecutor, again, appearing on behalf of the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Caldwell, who appears via Zoom, Your Honor. Mr. Caldwell, will you please state your name for the record?
Clarence Caldwell.
Your Honor, I see that you likely have before you what I believe to be a bond violation. Is that correct?
Yes.
And I did have an opportunity to go over that with my client.
Where is he?
He is in the state of Kentucky, Your Honor. That's where he currently resides.
He's gonna need to get here. But go ahead, here's what you wanna do today.
Your Honor, I am just asking for an adjournment. My understanding is that we will likely have resolution in short order.
Then what I will do, I'll give him time to get up here because he's gonna have to appear in person, February 12th, 2026, 9 AM. That's in person. We will deal with both his probable cause conference and bond violation.
Thank you, Your Honor.
This time his bond continues.
Thank you.
Court calls the case People versus Derek Riles.
Public Defender Hannah Apple appearing on behalf of Mr. Riles. And Mr. Riles, can you state your name for the record?
Derek Riles, thank you.
Mr. Riles is asking that this matter be set for preliminary exam.
Who is? Got him muted or kicked out. He wants an exam on it.
Yes, Judge.
Is discovery complete on it?
Your Honor, we are not in receipt of the video discovery. I did reach out to Ms. Tanhai yesterday, which would be the officer's body worn camera when they responded. She did let me know that she would look at the file. They have not received it from the officers. I explained that whole process, the position it would put his attorneys at if we did not have that video prior to the preliminary examination. At this time, he's asking that the matter still be set for preliminary examination, understanding those risks.
And slight update to that, as of, I think, late last night, I believe we did receive the video.
Oh, okay.
But if they're not here, I'm not gonna, an adjournment will not happen.
Yes,
You
he
understand
understands.
that, sir?
The first sentence, I didn't hear. What did you say?
If the video is not here on the exam date, you will not get an adjournment for that purpose. You understand that?
Yeah.
You understand you're not going to get an adjournment of your preliminary exam if we
I
don't have
want
the
it.
video. Okay.
Preliminary examination in person, February 3rd, that people can have their witnesses available that day. February 3rd, 2026, 9 AM before me. Bond will continue.
Thank you.
Court calls the case of the People versus James Wilson, 2 cases.
Veronica Glenn on behalf of Mr. Wilson.
Mr. Wilson, can you state your name?
James Wilson.
Thank you, sir.
Your Honor, we would like to set this case for a preliminary exam.
Both of them?
Yes.
Discovery is complete.
Yes.
People have their witnesses available the 3rd.
Yeah.
Preliminary examination in person, February 3rd, 2026, 9 AM before Judge Perry. Bond will continue.
Thank you.
Court calls the case People versus Daniel Sims.
Victoria Burton here as Chief Assistant Prosecutor, again, appearing on behalf of the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Sims.
Your name, sir?
James Simpson.
Thank you. What are we doing?
Yeah, this is going to be a waiver. Mr. Sims has some matters up in Judge Conlon's court. We're asking to waive this exam so this matter can go up there as well for a global resolution. I have gone over, or Mr. Sims is aware of his right to an exam and wishes to waive.
Mr. Sims, you understand You're waiving your right to a preliminary examination in this matter? Yes, sir. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them? Yes, sir. You understand you'll not have that hearing, you'll proceed to circuit court for further resolution? Yes, sir. You will also waive the
Yes, we do, Your Honor.
preliminary examination having been waived, defendants bound over to circuit court, 3 counts.
Thank you, Your Honor. In terms of arraignment on the information, we'd waive reading, stand mute, acknowledge receipt.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial will be set for February 4th, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor.
Bond continued. Court does call the case People versus Vasquez Davis.
Morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defender, Shannon Terry, on behalf of Mr. Vasquez Davis, who's approaching. Vasquez, state your name for the record.
My name is Vasquez Faison Davis, sir. How you doing today, sir?
I'm doing fantastic. Yourself?
Yes, sir.
You cold?
A little bit.
Yeah, okay. Then you're doing okay. All right. You're requesting an adjournment?
We are, Your Honor.
Probable cause conference will be adjourned to February 12th, 2026, 9 a.m. Bond continued. All right.
Thank you.
All right, bye. Take care. Bond continued. He's gone. Court calls the case People versus Alicia Wittenberg.
Alex Jablowski for the people. Assistant Public Defender Jay Bellinger on behalf of Ms. Wittenberg. Your approaches, Your Honor.
Your name?
Alicia Wittenberg.
All right. Have before me a plea form that indicates that she's going to plead to count 2, operating while intoxicated, second offense. She's going to plead guilty to that charge, the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. There is further an agreement that the defendant would be sentenced. The plea agreement is contingent upon entry into the 14B recovery court.
That's correct, Your Honor.
Has she been accepted?
She has been accepted, and the paperwork should be there and signed in front of you.
May I have her sworn?
Right. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, please.
Alicia Renee Wittenberg.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of operating while intoxicated, second offense.
Correct.
That is a misdemeanor punishable by up to 1 year incarceration, a $200 to $1,000 fine plus court costs. The court could also order any community service or rehabilitative programs the court deems necessary, could order your vehicle immobilized, could order your vehicle forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
I do.
All right. You understand also, ma'am, that while I'm taking your plea, I would not be your initial sentencing judge, but you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Judge who?
Barr?
Okay. I thought it was Washington, but yes, that's fine.
Well, ultimately, that's where we'll end up.
Okay.
All right.
I'm sorry.
But you understand that?
Yes, thank you.
All right. Understanding all of that, do you still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
I do.
You signed an advice of rights form or had one signed on your behalf?
Yes.
Any question regarding those rights? You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that with pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
I am.
And also because you believe that you're guilty?
I do.
June 28, 2025, at the location of Willis near Bunton in Augusta Township, Washington County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
I did.
Do you recall what you had and how much?
I do.
What'd you have?
I had almost a fifth of Captain Morgan.
All right. Were you stopped by the police or was there an accident?
Accident.
What happened?
I went into a ditch swerving from a squirrel.
You what?
I swerved to miss a squirrel and went into a ditch.
Should have hit it.
I know.
All right, anyway, I know that was wrong. Alan made me say that.
Oh,
He's
did he?
not a big squirrel fan. All right. That was very wrong. Did the police arrive?
They did.
All right, were you taken to the hospital?
I was.
All right, and was there blood draw?
There was blood drawn, yes.
And what were the results of that blood draw?
I believe it was 0.31.
0.28. We would stipulate to the 0.28 lab findings, Your Honor.
It was 0.28.
That's correct.
Thank you.
Of course.
All right. And you have no reason to dispute those blood test results, correct? Had you previously been convicted of operating while impaired on or about August 15, 2025 in the 34th District Court and or operating while intoxicated on or about August 9, 2017 in the 34th District Court?
You said 2025 or 2005?
2005.
And to the findings and recommendations contained therein. Is that right?
Yes, right.
All right. Anything additional from the state?
No, Your Honor.
Mr. Kirby?
Judge, nothing other than we endorse the probation department's recommendations, and my client is totally on board with what has been recommended.
What do you want to tell me, Ms. Thompson?
I've learned a lot from this experience, and it's got me focused on getting my life together.
All right. I do find that you are able to understand the nature of the proceedings and the charges against you. So I am going to find that you are competent to proceed in this manner, remitting to the probation violation, right?
Yes, Your Honor.
Based upon the admission, I find you have violated the terms of your supervision. I'm going to modify the terms of your probation to order that you enter into and successfully complete the mental health housing. I'm still going to keep the electronically monitored supervision requirement. Need to make sure that you're engaged in treatment and taking your medication.
Okay.
Okay?
Yes, sir.
Anything else?
No, Your
What's
Honor.
our jail days?
No, Judge.
I do not have that.
Okay.
I can provide that in a follow-up.
Okay. All right. Well, hopefully she won't get in any more trouble and it'll never matter. Good luck to you, Ms. Thompson.
Thank you, sir.
Did I say 25?
Yeah.
2005.
Yes, sir.
All right. Ma'am, if I accept your plea, I do have to advise you between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
I do.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No. None, Your Honor.
All right. And have I complied with the court?
Yes. Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter before Judge Barr will be
February 3rd at 10 a.m.
February 3rd, 2026, 10 a.m. before Judge Barr. Bond. Continue.
Your Honor,
You want me to, okay, go ahead.
I would ask to renew my bond argument. I understand that this court has heard this before. I understand also that the court is aware that Ms. Wittenberg has been able to be released as, upon the court order to an inpatient facility. However, the insurance in this case is not allowing, due to the fact that she has insurance, she's not allowed to be, she can't be released into an inpatient facility successfully. We would ask that she be able to be released on her own personal recognizance. She again does do.
I'm gonna let, I mean, I'll let you go on, but I am disinclined to change your bond at this point. I would let Judge Barr, in consultation with what's happening at 14B, once that is occurring, view everything and make a determination as to whether that would be released. Because they're going to have the most updated information.
If that is the court's order, Your Honor, then I will not continue.
That's my order.
Okay.
Bond will continue. Thank you. And Alan apologizes to all squirrels around the world. No, you do, don't you? You do? You're not even answering. Do you apologize to them? You know what? I'm gonna hold a special hearing about Alan and I'll do it. Yeah. Keep it up.
That's your last in custody.
Okay, court does call the case. People versus Ronald Fleming.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Fleming appears via Zoom from the jail.
All right, Mr. Fleming, can you state your name, please, sir?
Ronald Fleming.
Thank you.
Your Honor, can we briefly approach on this?
You may.
Thank you.
Would you do it for me? Just talk to him, even if it's just once?
Sure.
You will?
Yeah.
Okay, so here's what I'm gonna do. I'm gonna put it out a couple weeks. They're gonna get somebody down there to talk to you. And I'm doing that on your promise, you'll let them talk to you, okay?
Mm-hmm.
And then you'll come back and we'll see where we go from there. How's that sound?
Okay.
Okay. You want the 5th or 12th?
I think the 12th would probably
be better.
Thank you.
All right, so here's what I'm gonna do, Mr. Fleming. I'm gonna put this out, your probable cause conference, I'm gonna put that out to February 12th, 2026, 9 AM. So you'll come back and see me on that date, but in between, your attorneys will be down there and others may be down there just to talk to you, and you're gonna just talk with them a bit, and then we'll see where we go, okay?
Good.
Okay, thank you, Mr. Fleming.
Thank you very much, Your Honor.
Court calls case, People versus Grant Decia.
Morning, Your Honor. Raymond Cook, People.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Duche, who's approaching.
Duche, that's right.
Mr. Duche?
Duche?
Yeah, he was just in the back row.
Are you sure you saw him?
I met with him
Or
this morning in the little room.
worries me, Mike might be seeing and talking.
He was dressed as a rabbit. Pass him, or maybe he's in the lavatory.
There's a who?
Check. Would it be? Which one is it?
The D.
The Mr. Duche is not out there.
Let's say that.
Sarah needs to talk to her. Court does call the case. I'll pass that one. Trust me. Court does call the case of the people versus Ayana Fenn.
Morning, Your Honor, Raymond Cook.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Fenn, who is approaching, Judge.
Hi, Jonathan.
I have before me a plea form that indicates that what we're doing.
Yes, Judge.
Plea form indicates that she's going to plead to retail fraud in the second degree, the 1 year offense. Upon her successful plea to that charge, count one would be dismissed. There is a sentence agreement between the prosecutor and defendant of probation under the Home Useful Training Act. That's the court's full understanding of the.
That is correct, Your Honor. I have gone over her rights with Ms. Fenn. I've gone over the sentencing judge waiver process with her, and we're ready to proceed to that.
May I have her sworn?
Can you raise your right hand? Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name, please.
I got it.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud in the second degree. That's a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that? Yes? I need a verbal. Yes?
Yes.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes.
All right. Still wish to plead guilty?
Yeah. Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And you're doing it of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense? On date of October 14, 2025, at the location of 3070 Washington Avenue in Pittsfield Township, or in the city of Ann Arbor, Washington County, state of Michigan. What did you do at Lululemon that makes you think that you're guilty?
Walked out with items.
I'm sorry?
Walked out with items.
Okay, so you went into the store?
Mm-hmm.
Yes?
Yes.
The store was open to the public at the time?
Yes.
You took items
Yes.
and you tried to walk out of the store without paying for them?
Yes.
And you didn't have anybody's permission to take that property, did
No.
you? And the property that you took was property that Lululemon had offered for sale?
Yes.
And we're going on value, right? So
Yes.
Lululemon, of course. Was the amount, was it over $200?
Yeah.
Of
Yes.
course it was.
It was, yeah.
All
It
right.
could be a keychain.
What?
I think it could be a keychain. It'd be $200 there.
I'm not gonna make any comment on it. Just gonna say, of course, it was over $200. All right. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would first of all not be able to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from defense, Judge.
All right. And have I complied with the court?
Yes, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
8:30 before 30.
February 13, 2026, 8:30 before Judge Perry. Bond will continue. Thank you.
Okay.
There you
Thank
go.
you.
Well, thank you.
That baby was more behaved than most attorneys. You understand? Court calls the case, People versus Matthew Fitzgerald.
Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
And Assistant Public Defender Tanazi Carey Akinwumi, Your Honor, on behalf of Mr. Matthew Fitzgerald.
What? Hands out of your pocket. All right, your name?
Matthew Fitzgerald.
Thank you. All right, what are we doing?
Can we approach, Judge?
You two?
Yes,
All right, come on.
thank you, Judge.
This is gonna be a minute. I will continue.
Thank you so
All
much,
right.
Your Honor.
Thank you, Your Honor. Thank you, sir. Court calls case, People versus Dallas, Fritz.
Good morning, Your Honor. We can
Assistant Public Defender Jay Bellinger on behalf of Mr. Fritz, who should be appearing via Zoom, Your Honor. He is in treatment. No?
No.
No.
Wow. He's not here.
I'm not trying to bite anyone's head off here, Your Honor, but I know he's there.
He was hopeful.
We had a fruitful conversation.
Do you guys have like a different Zoom setting or something that he's on there? I know it.
He's on there somewhere. He's just like.
I wouldn't object if the court were inclined to pass.
Your Honor, I don't know necessarily how I'd be able to get a hold of him. He is in treatment.
Tan and whatever, and then somewhere like nice tan. What? I know. What does that mean? What?
A random client.
We have a
Take-
random sign.
I'll take
I don't know.
Oh.
Where?
At the bottom of your screen.
Top on the right. Okay. Sir? What's your name? No, you gotta unmute. I don't, is your last name Rosario?
Talk, baby. Baby. Say. No, they asking me. You.
Oh, no, it's Taylor. Taylor, sir. Mario Taylor.
Mario Taylor? Okay, thank you. That's not who we're looking for.
Your Honor, what I can say is that I do have Mr. Fritz's grandfather here today who can confirm that he is in treatment. I would ask for an adjournment so that I can attempt to get Mr. Fritz on a Zoom. We know he's there. We have been able to get, we were able to send the Zoom information. I'm not sure what happened, but I would plead with this court to give me an opportunity.
Plead?
Plead.
Plead? Why do you think you have to plead with me? You just give me some rationale for doing something.
Because I don't like kicking rocks, man.
What?
You know I don't like kicking rocks.
I don't even know half the time what he's talking about. No.
It's when you tell me to kick rocks and you give me a bench warrant anyway.
Wow. Okay, so we can be clear. That's because you've given me a bunch of gobbledygook I can do nothing with. And that's where they get a bench warrant. This one, grandfather's here, says he's in treatment. I believe grandfather, not you.
I'm cool with
So
that.
what I will do is I will adjourn. I'll adjourn the probable cause conference without objection to February 12, 2026, 9 a.m.
Thank you, Your Honor. I will do everything in my power to get him here.
He's not here.
Understood.
Yeah, okay. Who's that? Court calls case, People versus Craig Ivy.
Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Ivy. Mr. Ivy, will you state your name for the record?
Craig Ivy.
Thank you. Your Honor, we're asking for an adjournment. We have not received discovery on this matter yet.
You've not gotten discovery.
Correct.
I will give you what we have.
Okay.
I don't know.
Probable cause conference will be adjourned to February 12, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. Court does call the cases of the people versus Don Jones.
Assistant Public Defender Dodgy, leave on behalf of Ms. Jones, who stands to my right. Ms. Jones, can you tell the court your name?
John Rick Marie Jones, Your Honor.
Thank you.
And Your Honor, we're going to be requesting an adjournment. We're waiting to receive some additional discovery.
Probable cause conference will be adjourned to February 19th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Where is he?
He's in the wait.
We have Mr. Fritz.
Oh, sweet.
No, we don't. He just dropped.
Oh. But I told you we had him. I knew it.
Wow. Why are you coming at me? Oh, jeez. I believe everything that you say, Mr. I don't know. I was gonna say, I'll just leave the date where it is.
Thank you.
All right. Court calls the case, People versus Marcus Jones.
Are you ready?
Assistant Public Defender Dodgy, leave on behalf of Mr. Jones. Mr. Jones, are you present? Your Honor, I've not been able.
No.
Yep, I've not been able to reach him. Unfortunately, I did attempt to contact him.
Okay, he's not here at this point.
No, Your Honor.
All right. Going to issue a bench warrant for the defendant's failure to appear. Bond is set in the amount of $25,000 cash surety.
Thank you.
We'll issue immediately. Court does call the case People versus Ethan Jordan.
Morning, Your Honor. Raymond Cook with People.
Assistant Public Defender Jay Bellinger on behalf of Mr. Jordan, who approaches. Mr. Jordan, can you state your name for the record?
Good morning, Your Honor. Ethan Jordan.
Thank you.
Your Honor, we are just requesting a brief adjournment on this matter.
Probable cause conference will be adjourned February 19th, 2026, 9 a.m. Bond continued.
Thank you very much.
you.
Yeah. All right. We'll get it done.
Court calls the case People versus Christopher Lambro.
Assistant Public Defender Hannah Apple, appearing at Mr. Lambros. Mr. Lambros, will you state your name for the record?
Christopher George Lambros.
Thank you.
Your Honor, we are asking for an adjournment. We are missing some video discovery. Also, Mr. Lambros is awaiting, he's going to be entering treatment any day now. So we'd ask for
Okay.
lengthier.
So he's signed on his own. He signed up for inpatient.
Yes. Yes, he's going to Spera. He's calling every day as soon as there's a bed available.
Bed available, then he can go in. All right.
We could have an adjournment for that purpose.
Probable cause conference, February 19th, 2026, 9 a.m. Bond will continue. Good luck to you, sir.
Thank you, sir.
Court does call the case of the People versus Brian Laster.
Because it's from prosecutor on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Laster. Your Honor, unfortunately, I've attempted to make contact with Mr. Laster. I have not been able to speak regarding his non-appearance today. And I know that there is also a bond violation in the file.
Yes, sir.
For the record, I asked for an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond $25,000 cash surety. Warrant will issue immediately. Court calls the case of the People versus Tanisha Lewis. Lewis, is that you?
Good morning, Your Honor. Yes.
Okay, you got her. Okay,
Your Honor, you get my green paper?
I did.
We're requesting adjournment.
Probable cause conference in this one will be adjourned to February 12th, It's 9 a.m.
Thank you.
Bond. All right, thank you, Ms. Lewis.
Thank you. Have a nice day.
Court does call the case People versus Kristen Anthony in custody. Ms. Cannon. Or Ms. Glenn.
Veronica Glenn on behalf of Miss Anthony.
She's refusing to come up. So I'll give you an opportunity, since she's refused, to come up that I'll adjourn probable cause, let you try to talk to her to February 12th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Court does call the case People versus Kyle Burmeister.
Morning, Your Honor. People. Assistant Public Defender Jay Village on behalf of Mr. Burmeister, who is in custody.
He's also refusing. Your client's also refusing to come up.
Oh, okay, well, all right then. Well, I was gonna ask for an adjournment anyway, Your Honor, so I suppose it's just as well.
Probable cause conference, what did I said that last one, 12th, I know. I'll adjourn this one to February 12th, 2026, 9.
Thank you very much.
Bond continue. Court recalls case People versus Grant. Duche, I think it is.
Morning again, Your Honor. People. Michael Gaddy, Assistant Public Defender on behalf of Duche.
Your Honor, I was able to reach Mr. Duche, and he informed me actually, may we approach briefly? Probably some.
Yeah, very sure. Defense warrant will issue for defendant's failure to appear, bond 10,000. Cash surety, that warrant will issue immediately.
Your Honor, may I ask the court to give us until like maybe Monday to provide proof of where he is today?
No, I think I'm gonna have it issue immediately and we'll set it aside if you get the stuff.
Thank you, Judge.
Sign back in since we told you.
But I already checked this out.
Okay.
I think I did.
Yeah, you did.
I did, okay.
Okay, perfect.
Okay.
Yep.
Okay, so that's it. What, Mr. Taylor, was he in?
He's at 12.
He's on the 12 o'clock, okay. Very good. He's just early. Okay. And what I'm gonna do is I'm gonna stand in recess and we have a lot of things going on and then I'll come back hopefully at 12 and continue on courts and recess. All rise.
May be seated.
I'm waiting on that first page. I'm waiting on Reagan. Oh, there she is. Okay. She's working hard over there on making wheeling and then they can do it.
Yeah. Papa?
See. Your case in Mitchell, Christopher.
We're a little bit darker than that. And there's, do it right here. Perfect. Thank you.
You see the files on the second group. That's okay.
Do you want all the files?
Jason's. That's gonna be, he's in the middle of it. Jason Christopher. And then James Paget's, and that's gonna be the very next one. Okay, we call 25 CR 801 Christopher Mitchell. That's you, sir? Yes, sir. And Mr. Nix is here representing you. You're here today. It's an announcement. You were charged with state jail felony theft of a firearm, which carries with it up to 2 years in the state jail if convicted. What we do?
We've got some information that we've given to the state. And I think the state's going to look into that information and we should be able to make an announcement probably in 1 to 2 weeks.
If not, resolve it before then, Judge.
Ma'am?
This might be dismissed for a misdemeanor,
2
but
weeks. Okay.
2 weeks.
Yes, sir. Thank you, Joe.
Get a reset then. Thank you.
Here, sir.
James Paget. Where's James?
Working on
In the hallway, excited about that.
He's
tablet.
Brent's working on some stuff. Reagan, when you're finished, you got a bunch here, it looks like. Tell me when you're ready, okay? Okay, then we'll get you about 10 o'clock.
Okay, perfect.
All right, how about Alejandro Cruz?
He's here.
Just remind me what she has.
That reminds me, I was getting once, but I don't know what happened. But my watch is now 3 minutes slow, which has never been, which is maybe the battery. That's what the doctor said about me. That's strange. That's what the doctor said I needed.
What?
A new battery. She said I needed it.
3 minutes too slow.
Oh, yeah, that was 3 minutes behind.
Yeah.
That's pretty good, Joe. At least you're not funny. Okay, you were, Mr. Cruz, in 25 CR 804, Alejandro, you were charged with the state jail felony of burglary of a building. If convicted, that carries with it up to 2 years in the state jail, which is not a good thing. What are we going to do today?
There's just an initial, I still have the media on him if I have 4 weeks to get that.
Yes, July. He was indicted in July.
This is my first appearance.
I know, but it shouldn't take. Have you moved recently?
I was in custody in LA. I was in custody
Where?
in Brazil County. Sir.
To when?
About October.
For what? For a charge over there? What was it?
The same charge.
So what happened in the case? Did it get
sir? Yes.
It get disposed of?
Yes.
Okay. You know that?
I wasn't aware of that.
So
This is my first appearance, which is
I'm talking about over there, because I don't see a criminal history here, but you were convicted in that other one?
yes.
What was it? What was?
State jail 1244. They gave me
Oh,
1244.
1244. Okay,
Yes.
but it's still a state jail
Yes.
conviction,
Yes.
but you received punishment as though it was a misdemeanor.
Yes.
Those are good things if you can get them. And what was the crime?
Same.
Burglary of a building? Was it this? It wasn't the same of it.
No, it was
A different
to
event.
different
Okay.
locations.
Okay. Miss Hahn, you gotta get a resetting. Listen.
Yes.
Here, sir.
Chester Fobbs, please. FOBBS.
Sorry, here. Yeah.
I didn't want to read.
Camera left up, man.
Are you Chester Fobbs? I'm calling cause number 25, CR 1663. And you are charged here by an indictment with failure to comply with sex offender registration, which you were required for life, right? This, you have to do that for life. And this is a third degree felony. That's why you have to be very cautious and ensure that you register regularly and timely. Because if convicted of this, you are facing up to 10 years in prison. That's the way it is. It's a third degree felony for not registering properly. What are we gonna do for that?
Judge, I need some time to go over the media with.
He just got indicted,
It's new.
a couple of months ago, so I'll give you 4 weeks
Yeah.
on this. Are you registered properly now?
Yes.
I mean, there was a hesitation. You're nodding vigorously.
Yes. This
I
morning.
know, but you gotta verify.
Yes.
Does state know the answer to that?
I don't know off the top of my head. I can look into
Can
it.
you look? I don't want him leaving until I find out if he's registered properly right now. Okay? No, it's a crime.
No, I
And
understand.
it's
Judge.
gonna affect his bond if he's not. But he's got a duty to do it and he's got to do it. And I don't want you to leave until I know whether you have been properly registered and complying with this registration.
Yes,
Because every day it's a crime.
Yeah, change of address.
Is that what you did?
Yes. It came to Miss Key.
Okay, let's just verify it before Mr. Fobbs leaves. Okay, don't leave, make sure it's, we'll put this on the side. Here, I'll need this on the side. Remind me, Mr. Fobbs. I mean, that's
The reset.
legislature makes that very important. And when you get caught not registered, the first thing you have to do is register.
Yes, sir.
If you're not in jail already.
I'm sorry, I need you to sign right there on the high level. That's for me.
Just. Judge, you want me to sit over here? While they do it?
Yeah, I can see it then. Thank you. Ricardo Kelly. Ricardo Kelly, come forward, please. '23 CR 2261 is called. You are Ricardo Kelly?
Yes.
Wow. This is your first appearance in this case, right?
Yes, sir.
You were indicted over 2 years ago. You must have moved around.
Yes.
You're still at 11514?
No.
So what's your address?
947 West 13th Street. Hold on, Texas.
Hold on, Tex. You're shooting fast, in. Seven,
640.
I have 947 West 13th.
Yes, sir.
Okay. You're no longer at 11514.
No, sir.
That was it. That was the problem.
Yeah, no,
Okay, once again, this carries with it if convicted up to 2 years in the state jail. I don't see any prior convictions on this. Are you getting a lawyer?
I was supposed to be assigned a court appointed lawyer.
I'm sorry?
I was assigned a court appointed lawyer.
Why? I've been working since the day I turned 16. I paid my own way. Everybody else, if I can do it, anybody can do it. The people, the taxpayers are not going to pay your way. Are you able to work? Okay, I expect you to work and pay for your lawyer. That's what we all have to do. You're not going to rewrite the system. You've got to go and get a job and pay for your lawyer. Now, we're going to get you somebody appointed, but you're going to pay for the people of this county to represent you. They're the ones carrying the burden, but you're the one charged with the crime. They shouldn't be. Is that too hard to figure out? It's really not. You made a mistake according to the grand jury. Just like everybody makes mistakes, you got to fix it. And it's your responsibility, just like it's mine. And I have to put gas in the car. The person parked next to me doesn't pay for it. We've got to take care of our own obligations. And this is an obligation. I expect you, if you're able to work, to go out, get a job, and pay the people back who are going to be footing the bill for your representation. You understand? It's just the way it works every day. Not a free ride system. Somebody's paying for everything. And it's the taxpayers included, which you are included in that. That's why you gotta do your part like we all do. When was the last time you were employed?
I'm employed.
Oh, good. What are you doing? Okay, okay. Have you ever worked with them before? That company before? They have a pretty good deal going. And you're a manager? Well, you got responsibility. Okay. What do you make an hour over there? I'm sorry? $12. $12? Okay, that's 25. That's 25 annual. One thing you need to do, he needs to fill out one of these, incomes, financial forms. That's not in here. And that has to always be in here when, somebody is, not represented by a retained lawyer. So you're gonna have to fill that out. I'll look at it. And we're gonna get you some help until you can hire somebody. We're going to get you some help to represent you, one of the public defenders here. Okay. And we'll introduce you to him. Fill that out first, though. Okay. Right over there in the box. Okay. We're going to just reset this for, a review in about 4 weeks.
Yes, sir.
Okay. William McGinn is called. And that's cause number 23 CR 2021. There's no answer in the courtroom. And I'm going to ask the bailiff to be so kind to call into the hall for William McGinn. What are you drinking? Okay.
Yeah, tell you guys, I'm not the recipe.
Well, yeah, I've already, Charlie next to you can smell it.
Strong coffee.
That's not what he said, but he did say strong.
It is strong. No response.
Okay. On William McGinn.
Yeah.
In cause number 23 CR 2021, the defendant is charged with, there's a motion to revoke unadjudicated probation. And he is on 10 years deferred or unadjudicated probation for the state jail felony of criminal mischief. And there are no less than 6 allegations of violations of probation. There is no answer to the name call here in the courtroom, no answer to the name call out into the hall. What is defendant's bond? Defendant has failed to appear.
Judge, it looks like we initially had him at a hold without a bond. It was an NPRP. He was arrested in Harris County and they set the bonds at $10,000 on each case. So I don't know if you want to put it back as a hold without bond that we had previously. But we did not set those bonds. Harris County did.
Okay. It would certainly be nice, since that's all a matter out of this court, that he should have been called and talked to. Oh, but the left hand and the right hand are not working together here on that. Okay. The defendant's bond is revoked in each of those cases. I'm setting bonds of $20,000. Plus, he has to have a GPS device as a condition of bond, so we know where he is when he's not in court when he's supposed to be. And a warrant will be issued for his arrest. Yeah, thank you. I'm not sure I can revoke their bonds. Now I'm thinking about it. They set bonds, but that's. Did they set it in a case they have or?
No,
in-
they aren't cases.
Okay, well, then I can change those.
And when he was arrested in Harris County, they set bonds.
I can overrule them in those circumstances. So those are $20,000 bonds. I don't know why I almost said that way to. And that's, that's those findings and rulings of $20,000 bond and a revocation of the previous bonds of $10,000. That's in each of the cases, which are 23 CR 2021, criminal mischief, and 24 CR 1455, illegal possession of controlled substance. Tevian Thomas, please. Is called next. Tevian Thomas, 25 CR 1774. No answer in the courtroom. And I'm going to ask the bailiff to once again make a call into the hall for Tevian Thomas. Tavey IAN. Tavian. Here's Mr. McGann's.
Yeah, 2 cases. You give me one. I need the other. There we go. Thanks.
This is 25 CR 1774.
No response.
There's no answer to the name call here in the courtroom. No answer to the name called into the hall. Defendant has failed to appear. And he is indicted for the 2nd-degree felony of aggravated assault causing serious bodily injury. What's his bond, please?
Judge. It does not look like we have the bond back yet. That's a paper bond, so.
He has failed to appear. A warrant shall be issued for his arrest, and bond in the amount of $50,000 is ordered based upon the circumstances. And in this case, as the court is looking at the probable cause affidavit, I do need a copy of the public safety report for him before I finalize this.
I understand, Judge. I'm looking, this looks like we have the paperwork back on this yet. Looks like he was arrested in a separate county. We don't have that paperwork yet, Judge. So I don't have the public safety report as of yet.
Okay, we can order one. We can order one. Yeah. Well, I will do it later. I'll do it later.
We need to make sure because he didn't go through on jail. He was arrested in another county. So, and we typically do this paperwork, but we don't have it. It's not in our file yet.
Well, I've got to have it.
I understand.
Set a bond.
I mean, we can set this to the side and I can try to call and see if I can pay.
All right, let's put it aside. Put a little asterisk on it and we'll get to it.
Okay, yeah, we can do that.
Don't forget. Thank you.
Okay.
Brent?
Yes, sir.
Hey, I've got Kempa Fontano
So,
Okay.
and Kempa Fontano, 2 cases.
Okay. Let's get them.
I'm sorry. Concur. Is this one and plea of use?
Okay. You swear or affirm the information in this document is correct? You can have a seat just to play back on, right?
Hold on, just a second. What are we doing today on this?
Judge, we literally just got discovery last week. The state just made her an offer of 2 years. Ms. Fontenot would like to consider it and visit with me.
We got some issues here. We're gonna have to take up. Okay. So I'm looking at, first of all, you are Kempa Rochelle Fontenot.
Yes.
Mr. Turk is here representing. I'm looking at the two cases, and they were indicted at different times. The earliest is an indictment 24 CR 2421.
Every 50 years. I just wanted to explain her. She's continuing to come, so we must continue.
And it alleges that
She's about 15 minutes away, but.
on or about October 13th, 2024, in Jefferson County, Texas, you committed the state jail felony of credit or debit card abuse by
See what he wants to do.
misusing someone else's Citibank credit card, it looks like.
My daughters, we want to see my daughters. But no big deal. Because I caught her when she was running late, she was having to stop.
Yeah.
Still with Mr. Here's just Stephanie's.
Oh, thank you. Okay. That's the question I'm going to ask. Who's going in back?
So police, in that case, on that event, based upon that event of October 13th, 2024, filed a probable cause affidavit on November 12th of 2024 after speaking with the defendant, who admitted to using the card, and then that probable cause affidavit was filed into the records on that date, and the defendant was indicted on December 11th of 24. However, after that meeting and discussion and probable cause affidavit was filed, again dated November 12th, 2024, after the police had interviewed the defendant. Apparently thereafter, she goes and misuses a credit card on November 30th of 2024, which would have been about 2 weeks after she had met with the police and admitted to using that credit card. That is what is represented in 25 CR 645, where it is alleged on or about November 30th, 2024, she misused another credit card. These are both state jail felonies, which carry with it up to 2 years in the state jail on each case. What a surprise. I mean, what's disturbing is they caught you, they met with you, thereafter you do it again. You victimize another person just a few weeks afterwards. That's dangerous for people.
Judge, on the 24 case, 24 DCCR, the bond is $30,000. I mean, 25 BCCR, it's $5,000,
It's what?
5,000.
Yeah, see, it's like, what?
Well,
Yeah, it's quite naturally, you commit another offense after you were put on notice and they make a much lower bond subsequent. Well, it's obvious whoever did that must not have been aware of what the circumstances were, because that's preposterous. I mean, that doesn't make any sense. You have to pay a higher price for subsequent mistakes. That's the way the criminal system works. Otherwise, I mean, it would behoove people to keep making more mistakes. They get lesser punishment. That doesn't make any sense. Your bond is going to be changed on that second one. That is obviously an incorrect and invalid amount based upon the findings and what supports the evidence in this case. It's preposterous. And what happened was she goes out and commits the same offense again. And then it's 15% of the value of the previous bond. That doesn't make any sense. So her first bond is how much?
30,000, and on the 24 BCCR,
Your bond,
the second one, the 25 BCCR, it's 5,000.
yeah, your bond is not 5,000, it's 60,000 on that. It's doubled. It's doubled for the subsequent alleged bad behavior, which is exactly a photo image of what the police indicted you for and what they investigated and met with you and discussed in the first case. So
Judge,
that's the rulings. That's the finding of the court. And you'll be taken into custody until you can post that bond. Plus, you're going to have a GPS device.
he has the GPS check.
Okay, that's good. And you cannot make any financial transactions with any credit cards or any other financial instruments except through the approval of this court. You're dangerous, and other people are being punished because of your actions.
Judge, are you saying she cannot use her own credit cards?
As long as they're her own, but I want to know, she's not charged with that. She's charged with misusing others.
I understand. I was wondering.
That's why we're here. Yeah, I'm sorry. There's a way to avoid that. Don't commit a crime. It's not a debate, ma'am.
So
you don't get a lesser bond. You can shake your head all day long. You can shake your head all day long, but that defies logic and the law. That's what the ruling of the court is. Her bond is $60,000.
One case or on both cases?
The second one. Oh,
so it's 90,000 total.
Yeah. Yeah.
Judge, she's clearly here on an initial docket. She's been communicating with me. She's interested in her case, and the purpose of a bond is not to punish anyone, is to make sure that they show up in court.
I wrote the article on that. I know what it is. Yeah. I know what the purpose of the bond is, but it's also for the safety of the community. Otherwise, somebody can, who does terrorism can post a bond and continue to do that. But where is the logic in allowing people to commit subsequent crimes? I can guarantee this, that misusing credit card hurts the victim far more than it's going to hurt her, because they're stuck with an issue of dealing with their credit worthiness for the rest of their life almost. We all know the way that works.
I think everything was returned, Judge.
Nonetheless, it's in the system.
Well, the defense objects to that, Judge.
Yeah, okay. Your objection's noted, but her bond is now $60,000. What are we going to do before? Hold on. Oh, Kendall, let's take care of the hearing first, and let me finish this before we take her into custody. Okay.
She was saying she had checked herself into
Revive Recovery Center in May. Not for any other reason It was before any of this had come about. It was strictly Judge Stevens knowing where I was headed, where I was going, and the behaviors that I was
I
committing.
don't understand what you're saying. Start from the beginning.
I had checked myself. It's not anything to
You're not
make you
finishing any
feel like
sentences.
any type of way or anything like that. I'm just saying, like I've been trying to do everything that I possibly can to do, make sure I start going back in the right direction. Yes, I did start on whenever I relapsed in November.
For what?
And
You're not completing
24
this thought.
And
For what? Do you have a substance abuse problem?
yes, I
Okay,
do, and I
okay.
did, and I've regained back control of that back in May whenever I checked myself in a revived recovery center and inpatient treatment. And whenever I was in Orange County Jail, serving the time on my MTRPs, Judge Arkeen gave me a reinstatement on my MTRP, and I was just in hopes that since I was trying to do the right thing and I was headed back in the right path, that maybe
What were you on probation for up there?
I have in 2017, I
What
got
were you on probation for?
for credit card abuse and burglary of a habitation.
Okay. You're still, and so we're back here with credit card abuse again?
I got
Is that right?
reinstated on, yes, sir.
I think it was in about the same time frame as those judgment fees. I don't think they're,
Did the judge in Orange know about these new cases?
Yes, sir.
Oh, well, that's her decision. That's not mine. She can do whatever she wants on those cases that are before her, but generally, people who are on probation for an offense and then or there's a motion to revoke file for committing the same type of offense, they're pretty much dealt with strictly. But that's so when did you go to the recovery center?
Checked myself in May.
Of what year? The 2000s.
last year,
25.
last year.
When?
May of 25.
How long were you there?
Month and a half. The program can continue into 3 months, but I only did not continue the program for the 3 months because I had to report to probation.
Okay, so you didn't complete the program.
I did complete the program, the inpatient treatment, yes, sir.
How did you do that? I thought you said you didn't.
No, the whole 3 months, there's 30 days of inpatient, and then you transition into sober living, which I did that as well. And however long you stay in sober living is however long you stay in sober living. That's up to you.
Okay.
Sounds like she's completed the initial.
Okay, I want the certification of completion. Can you give me a copy of that?
She needs to be out to help you do that, Judge.
No, she's not going to be released except under this court's orders. She's committing crimes while she was on probation, apparently, and while she had committed the same types of offenses.
With the judge entertained, like $30,000 for both instead of
The 60 for it's the one is revoked and the bond is 60 total. It's total.
for both.
Yeah.
Okay.
Yeah. That's what I do. I revoke and then I accept one bond for all of them.
Thank you, Judge.
But what was the substance abuse? What was the substance you were abusing? I'm sorry?
Opiates.
Did it start with like a prescription?
Yes.
Started with a prescription, Judge. Probably was it like.
And then what?
Sort of prescription of Norcos for a congenital effusion.
And then what?
And then, after Norco, I guess the next thing that was available
30. Yeah. Thank you. Yes, you got to post a bond,
Right, and the bond is 60,000, Judge?
30.
30.
Yeah, and the other one's 30. There's. I'm not going to tamper with the other ones. Marvin Lewis.
Yes, sir.
Hey, Marvin. Carla Williams, please.
She's easier.
They call her back there.
That's the point.
Who's that?
One of the woman who just one of the.
Wait, hold on. What's going on here?
I saw them call her back.
What's this? Kendall, do you need this lady?
No, ma'am.
All right, you need to sit.
You to do something, I need you to do it.
See,
Go sit down in the gallery, please.
thank you for following the rules and directions. Marvin, what are we going to do on Carla Williams?
Ms. Williams, yes. I've been talking with the state about a possible resolution on this case, and I think we can get it resolved. We just need.
a few weeks,
How much are we talking about?
3 weeks, 4 weeks.
3-4 weeks.
Yeah, okay. Done. Thank you. We said 3 weeks on this. Please get a resetting from that lady. Thank you. Timothy Cater,
I'll shoot you.
Mr. Maker.
Here, that's a plea.
Katir. I'm gonna need some files.
Yes, that's fine.
It's all right.
Marvin, give me just a second, okay?
No problem. My client
And he
is
needs to
just.
come square in front of me.
James, your client is where?
Oh, what?
Is that you?
What's right there?
He's right behind you.
I thought I was.
Surprise. Oh, you need to see this lady. She's going to swear you in, sir. Thank you.
Yes, sir.
Mark, how long are we moving on?
Okay. Sign on the highlighted X for me, please. I know what mine is. This is Cater.
Hey, Marvin. Take care, buddy.
Your 75?
Yes.
Okay, and your right thumb print. Place it flat right there on top. Keep that one more time. And place it right there. There you go. You can stand on judge.
25 CR 400 is now called the State of Texas versus Timothy Cater.
Cater, Your Honor.
Cater?
Cater, yes.
Cater. And you were here with Mr. Macon, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment
Yes, sir.
and the arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about February 2nd, 2025 in Jefferson County, Texas, you committed the state jail felony of being involved in a collision which involves injury to another. And apparently you intentionally and knowingly left the scene of the accident without following the rules of the law and providing information. This is a state jail felony. Do you understand what you were charged with, sir?
Yes, sir.
Was what happened to the other driver?
They went to the hospital and were released, Your Honor.
That's
What do you
correct
know?
to my knowledge. There was some injuries, but
What was
nothing
it? What were
severe.
the injuries to you?
Grapes and abrasions.
Well, because the indictment says it resulted in serious bodily injury. Is that not wrong?
Well, with them going to the hospital and
I'm listening intently. How you're going to explain this one? grand jury that's saying something different from what you're saying.
Well, from the information I have, Your Honor, they just were kind of bruised and shocked and all of that. They were on a motorbike that was weaving in and out and
Oh, you understand what you're charged with?
Yes, sir.
This is a state jail felony, which means if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached where you would be pleading guilty. Be placed on deferred or unadjudicated probation, which can be up to 5 years in length, fined $500. And what is restitution here?
We will have to determine probation.
Restitution, which is to be determined, we're going to have a pre-sentence report done anyway and prepared. That will, or a post, we'll figure it out here in a minute. And the court needs to know if and how much restitution is involved. That will be a mandatory condition of probation. Do you understand?
Yes, sir.
Your Honor, I've been given information that Mr. Bennett is hiring a personal injury lawyer to sue too.
That's correct, Your Honor. There is a civil suit pending between these parties as well.
That only meant a lot to me. In criminal, I'd be worried about it, but I'm going to make my own findings and he will be given credit for whatever it's the civil side does, whatever that may be. But restitution is going to be ordered by and through him in some way or through his insurance representatives. But they're not the one liable. They're liable to him. He's liable to the victim. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked at State's Exhibit 1 here. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all proven correct?
Yes, sir.
State's Exhibit 1 tendered into evidence
No objection.
without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been brought to you. You read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial. Rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Is pre-sentence report waived on this?
We'd waive it, Your Honor.
Okay. If nothing further, I'm going to make the findings that you are mentally competent to enter this guilty plea. It is freely voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. But I'm going to follow this plea agreement and defer any finding of guilt. Postpone so long as you follow the terms and conditions of probation. In this probation order, you will be placed on probation for 5 years. You do well, it can be shortened to 1/3.
Yes, sir.
There will be terms and conditions of probation. The probation officer will go over with you. The one thing that we don't have, there's a $500 fine among other conditions, but the restitution with it, which is going to have to be determined later upon more investigation on this through the probation office's efforts, but that will be your responsibility. If there's an issue of how much it is, then thank you. If there's an issue on how much it is, then the court will resolve it in a hearing that we're all parties to be heard. Okay. Anything else? So please see probation. Thank you.
That lady right there did wait in the outside.
This is not good. I'm on warrant duty. I'm on bullet warrant duty. It's already been a long week. Stand by everything. I didn't.
I
We
believe
don't
it,
have it in that file, do we? Do we have any other files on it?
it was,
Oh, I-
from late last year. It's not set today, Your Honor, but I believe that's what the warrant's on. It's for a
What's the time?
burglary of habitation.
Burglary of habitat.
I was not aware of it.
Mhm.
Well,
We're only today on the docket, the only thing that's said is Mr. Paget's case, but there is another felony case that's,
Judge, if he wasn't arrested on it, it wouldn't have been on today's docket.
I believe that's what the warrant is for.
Yeah.
And a misdemeanor.
my understanding is there may be a misdemeanor.
And a misdemeanor.
There is also a warrant for misdemeanor.
For what?
Well, harassment. So burglary of a habitation and a harassment.
Okay. So he's gonna have to deal with a couple of extra things in there.
Sounds that way, Your Honor.
Dwayne Francis.
We turned in plea papers on Mr. Francis, Your Honor.
Come on up, Mr. Francis. Thank you.
Swear in front of the-
Your Honor, I have, if we could address one more situation while he's getting sworn. in.
Yes.
I have a meeting was on your docket this morning.
Morgan.
Now she's
Mr. Francis.
from Houston and she's here now. She's late, but she's sick. So she's,
Where's Morgan?
she's in the hallway. I don't think, before you bring her in, she's been sick. She's been feeling, okay, you want.
Okay, all I wanted is to just be at the door and wave so we can say on the record she was here.
Okay, but she's had the phone call over 3 or 4 times. And calling me the whole time. She's been extremely sick.
Need some help.
Introduction.
So before we call her in,
Would you be so kind to keep, you don't pay extra for these things, there's a Morgan. I just want Morgan to have the broad line forward so I can see her, she's ill. So, according to James.
so she tells me.
Make sure she's here and then we're gonna send her off. Thank you.
I just,
On Morgan means, I'm gonna reset this,
You don't have discovery
But-
here on me.
I didn't.
but Lisa.
That's what Mr.
How do we get?
Can we do one for all? of them?
That's
I don't mind.
The bondsman will get it, and they'll tell her.
Okay. I
Yeah,
mean, we're just gonna do that through the bondsman. How much time? Is
Whatever pleases the court.
He's good on that.
I have an offer and I have discovery, so we're ready to go.
Morgan? Your Morgan means?
yes.
You're gonna get a resetting for 4 weeks from today. He will be, Mr. Paget will talk to you and your bondsman will get with you. You're released.
Thank you for helping me with that one.
She's not feeling well.
That would be.
I don't want everybody to, I don't want anybody else not feeling well.
That's our goal.
Okay, how many cases do we need? on
Four.
this? Four of them?
Cases, Judge.
I just sent through the last one.
I don't have any files. Here, I'm gonna give you this one back. Dwayne,
Things going right now.
Dwayne Francis, this is it. Okay, we've got four. How many will he be pleading to today?
All four, Judge.
All four?
Correct.
Okay.
There's good reason for
If I
it.
could only get paid by the case, boy, that'd be
That'd be nice,
rich as
Judge.
some of the lawyers in this room. They don't include me.
Yeah. I'm a wealthy. Just live with you.
Oh.
The way you're talking.
The poor boy me. I know.
I'm wealthy with family
Yeah.
and children that have been educated with my money.
They're taking care of you.
Yeah, 4 with 2 degrees each. Unfortunately. I only have one more on the payroll.
For how long?
2 more years. She's a junior at A&M, less than 2 now. Or a year and a
That's
half.
great. What's her major?
She's a technology girl, human resource technology. She's already working full time, so she's getting a real estate license.
Oh, she's working full time.
Yeah.
Okay. Well, you can just about retire now.
Yeah, I'm getting close, actually. We're not paying for the second degree.
4 cases are now called. You are Dwayne Joseph Francis Jr., sir?
Yes.
And you're here with Mr. Paget, your attorney and the state's attorney. Does the defendant waive formal readings of the indictments and arraignments in each of these cases? Can we proceed in summary?
Yes, Your Honor, we can.
First of all, we'll do it numerically. 24 CR 1437. In summary, this indictment alleges that on or about May 5th, 2024 in Jefferson County, Texas, you committed the 3rd-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with in this case, sir?
Yes, sir.
If convicted of a 3rd-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. Fine $500. This will run concurrently with other cases that you're going to be pleading guilty to. And I can shorten your probation to 1/3 if you do well.
Yes.
Do you understand what you're charged with? And also, is this the agreement you've reached?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this case? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
Next, we go to 24 CO 1438. In summary, this indictment alleges that on or about March 12th, 2024 in Jefferson County, Texas, you committed the state jail felony of theft of property from, and the victim is Jefferson County Drainage District 6. Do you understand what you're charged with? This is a state jail felony, which means that you were looking at, if convicted, no less than 180 days or more than 2 years in the state jail. And you can be assessed a fine up to $10,000 as well. Do you understand?
Yes.
The punishment range applicable. The agreement's been reached in your case where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 5 years in length. Is there any restitution on it?
None, Your Honor.
Really? Okay.
The
He
property
admitted-
was returned.
It was returned.
Yes, Your Honor. In all of the remaining cases, there's no restitution.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes.
How do you plead in this case, guilty or not guilty? Sorry.
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Now go. You're going to put that one on hold as well for the time being. Go to 25 CR.
You gotta take care of. Court does call the case of the people versus Quan Patterson.
Good afternoon, I'm Robert Jacob on behalf of Mr. Patterson. Mr. Patterson, state your name. Juan Patterson. Judge, I was just appointed. I spoke with Mr. Patterson last night. I sent him the police report. Mr. Patterson says that he has hired Mr. Goldstein. I talked with Mr. Goldstein this morning. He asked if we could adjourn this 1 week on his behalf.
1 week?
That was Mr. Goldstein's request. You
Okay,
being
that's
the
not happening.
considerate judge you are,
That only works for your cases, but this isn't your case anymore. Probable cause conference. Well, is he gone in February? I think
I
he's
assume-
gone the whole month. That's why he's asking for the week.
I would assume so.
Case of the people versus Jimmy Leo Murray.
Roger Green, defendant. Good afternoon, Your Honor.
Good afternoon, sir. How are you?
Thank you. Thank you, Your Honor.
Yes, sir.
Your Honor, this case is tied to a case in circuit court in which my client is going to be sentenced on the 11th of February. And there's a good chance that after sentencing, this case may be dismissed or disposed of. So we're asking for an adjournment date to maybe the 12th of February, if that's available.
Okay, so he's being, just so that I'm clear, he's being sentenced in circuit court. As part of that, this case might be dismissed.
That is correct.
At that. Okay. Any objection from the people to the adjournment?
No objection to adjournment.
Okay, Mr. Green, I'm probably gonna need you, because this was a public defender case, wasn't it? He was pro per and then hired Mr. Green. Okay, the appearance will do then. Alan.
Do I need to sign it? Yeah.
That usually helps.
Yeah, then.
Yeah, I need your signature.
I understand, Your Honor.
Photocopy, I need.
Oh, so they were, it might
It's a
be.
terrible
All right,
photocopy.
got it. Okay, just take care of it. I will adjourn this matter then to February 12th, 2026, 9 a.m. or as your invite indicates, bond in this case will continue. Thank you, sir.
Thank you very much. Your Honor. Thank you.
Court does call the cases of the people versus Mario Taylor.
And good afternoon, Your Honor, and to your staff. May it please this most honorable court, Mohammed Nasser, P74485, preparing on behalf of Mr. Mario Taylor, who appears via Zoom, consents to the hearing over Zoom. Sir, please state your full name for the record.
Mario Taylor. All right. What are we doing on this today?
Happy New Year, Judge. May it please the court, I was requesting a continuance of the PCC and asked for about 30 days. There's additional discovery review, and my desire is to submit a deviation.
You need 30 days? Discovery not there or what?
No, I apologize, Judge. I start a jury trial on Monday, which is essentially, well, not essentially, it is 4 cases that's been consolidated into one, so that will take about 2 weeks. That's why I'm asking for 30 days.
February 19th, 2026, 9 a.m. or as your invite indicates, bond will continue.
Thank you so much, Judge. Always a pleasure seeing you.
Thank you, sir.
Have a good day, Judge. Thank you again.
Court does call the case People versus Adam Allen.
Good afternoon, Your Honor. Daniel Lehman on behalf of the defendant.
Sir, can you please state your name?
I'm John Allen, Your Honor.
Thank you. All right, what are we doing?
We'd like to see if I just got into this matter. Like to see if we could post or continue this for 30 days for plea negotiations.
You need 30 days to. Any
Yes, Your
objections from the
Honor.
people? Thank you. February 19th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor. Yeah.
Court calls the case People versus Joshua Steuben.
Good afternoon, Your Honor. Raymond Cook for the people.
Daniel Lehman on behalf of the defendant, Your Honor. Joshua?
Yes, sir.
Oh, please state your name for the record.
Joshua Steuben.
Going on this one.
I just received discovery yesterday. I'd like to see if I could push this back 30 days for plea negotiations and review.
All right, just so that you're aware, I'll do it this time because you have the other case. I don't typically adjourn things out 30 days. I think you guys can probably read faster than that.
Understood, Your Honor.
Probable cause conference, February 19th, 2026, 9 a.m. or as your invite indicates, bond will continue. I'm presuming there's no objection to this. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case People versus Melvin Lilly.
Assistant Public Defender, Chinazi Kiriaki, Your Honor, on behalf of Mr. Melvin Lilly, who is approaching. Mr. Lilly, state your name for the record, please.
Melvin Lilly.
The court should have a green sheet.
Sir, you should take your hands out of your pockets, please. Grant the request for an adjournment. Probable cause conference will be February 12th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
And court does call the case of the People's State of Michigan versus DeLand McMullen.
Good afternoon, Your Honor. Raymond Cook for the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. McMullen, who's here to my right. State your name, Mr. McMullen.
McMullen. All right, I have a plea form in front of me that indicates that the defendant is going to be pleading guilty to the charge of improper possession of a firearm. The 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed. And defendant is agreeing, but I think he has to forfeit the pistol to the Washington County Sheriff's Department. That's the court's full understanding of the agreement.
That's people's understanding.
Defense's understanding as well, Your Honor. I have gone over his rights with Mr. McMullen.
May I have him sworn?
Raise the right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Sir, it is this court's understanding that you're going to plead guilty to the charge of improper possession of a firearm. That is a misdemeanor punishable by up to 90 days in jail, a $100 fine plus court costs. You understand that?
Yes, sir.
You also understand that while I'm taking your plea, I would not be your sentencing judge. And you would be sentenced before Judge Washington in the 14B District Court. You understand that, sir?
Yes.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights? Please look at paragraph 5. Copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense? On the date of January 28, 2024, location of Grove Road near Harry Street in Ypsilanti Township, Washtenaw County, State of Michigan. Did you have, what kind of weapon did you have on you?
Glock 43X.
Okay, was it loaded?
No.
All right. And where did you have it at the time?
Under the driver's seat.
Pardon?
Under the driver's seat.
Okay. And you don't have any authority to have that weapon and carry it in that fashion, do you?
Believe not, no.
Pardon?
No.
Sir, if I accept your plea, I do have to advise you that if you commit misconduct as defined under the Michigan court rules between the time of my acceptance of the plea and the time of your sentencing, that you would first of all not be able to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None from defense, Judge.
Have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B. Probation. Sentencing in this matter will be
It's 10 a.m. before Judge Washington.
February 26, 2026, 10 a.m. before Judge Washington. Bond in this case will continue. Thank you. Court does call the case People versus Rio Page Pollard.
Good afternoon, Your Honor. Assistant Public Defender Davey Lebo on behalf of Mr. Page Pollard, who is entering. Page Pollard, can you tell the court your name?
Real chance, Page Pollard.
And can you take your, thank you. And Your Honor, we did just receive an offer. I'd like to take a brief adjournment in order to review that with Mr. Page Pollard.
Probable cause conference will be adjourned. Going to need to go to the 12th. So February 12th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. You two are going to have to move from those seats, please. They'll go right out. They can come right out. I call them. That third row. Row 3 empty. I want to make sure. I need my prosecutor. Why? They're on their way. They coming down this way or that way? Court does call the case of the People's State of Michigan versus Sharon Moore. Counsel, please state your appearances for the record.
Good afternoon, Your Honor. Katie Rismersky for the people. Good afternoon, Your Honor. Ellen Michaels on behalf of Sharon Moore, who is present in court.
Your name, sir? Sharon Moore. All right, thank you. Can you grab my file back? Because I don't have it. Michigan versus Sharon Moore. Counsel, please state your appearances for the record.
Good afternoon, Your Honor. Katie Rismersky for the people. Good afternoon, Your Honor. Ellen Michaels on behalf of Sharon Moore, who is present in court.
Your name, sir? Sharon Moore. All right, thank you. Can you grab my file back? All right. Date time set for probable cause conference. What do we need to do today?
I've had the opportunity to talk with the prosecutor. There is outstanding discovery that we need to have before we can proceed to exam. So we're asking to adjourn the probable cause conference for 30 days to receive that discovery. And the discovery, we're talking about our phone records and Title IX documents.
Okay. Are the people going to be in possession of Title IX documents or have access to those? I guess.
It's a very good question, Your Honor.
Thank
My
you.
best understanding.
I usually ask good ones.
You do.
Go ahead.
This court always does. My best understanding in the moment is that this is not a Title IX investigation per se. My information is coming in real time, as they also say. It was a complaint apparently to the Office of the General Counsel. I have just moments before we came onto the record been informed that there is no written report. That is my best understanding. Whether or not there is some other kind of investigative information that exists has yet to be ferreted out. That effort, that process is ongoing. Ms. Michaels is correct in the aspect of phone records are being sought. All of the, just so the record is clear, all of the evidence and discovery that we have has been furnished to defense, but the investigation is ongoing.
Okay.
Whether or not 30 days is sufficient is a live and good question.
Okay, well, let me just make sure that I'm clear. Whether 30 days would be sufficient for phone records is questionable, or for everything that Ms. Michaels indicated?
I believe my thought was everything, but I think that also applies to the phone records. Quite frankly, Judge, I don't know what that timeline is. I can try to find that timeline out and communicate that to the court and counsel, but I don't have that.
Okay, and I guess I'm not, what I don't want to get to, I guess, is a point where we're at a certain point, it may be ready to be set for exam or do whatever, and everything that these records, I'm presuming, Ms. Michaels, that you're saying from the U of M, that are records from the U of M.
Correct. It's our understanding that when you just step back a touch from the actual incident, there were statements made and things done earlier that day to the U of M, statements made by the complaining witness that are going to be important to this investigation because her credibility will always be an issue, and different statements she made to different people will need to be evaluated. So those statements are important.
Okay, I get that, but those, I mean, aren't those documents or statements that you can get on your own, or?
That's a great question. If the court is willing to sign a subpoena, I will send a subpoena myself. I don't.
Depends on one's view of life.
But I take no issue with discovery flowing through us.
Yeah,
in terms of
right.
this
I don't have a problem with that either. It's just, I'm trying to figure out if the request is made. So, because are you attempting to try to obtain those documents?
I am.
Okay. And then once you obtain them, if you do obtain them, you're going to inform counsel or provide them to counsel.
Immediately.
Gotcha.
One more thing, Your Honor, for due diligence sake, maybe I should submit to the court a subpoena for signature, and of course, I'll serve the prosecutor, and I can also submit a subpoena requesting those records, having them returned to the court.
Well, having the results come to the court.
Correct.
Okay, and then we would, okay, I don't have a problem with that if we're the go-between that comes here and then goes out. I don't necessarily have that, so unless there's some legal objection to it, if you submit a subpoena to the court, I would sign off on it, I guess, to try to get this, so we can get this thing moving. 30 days. So there's also, and just so that's a discovery issue. Today, I guess that was filed a motion to quash.
That's correct. Earlier today, I, at the court window, filed a motion to quash the arrest warrant and a request for a Frank's hearing. I have a signed copy to tender to the prosecutor, and we will be asking for a hearing date on that motion.
Okay, do you want two separate dates? I mean, how fast do you want? Well, first of all, I mean, the people have to answer. So
sure.
I guess how fast do you want this?
This can,
and what I'm indicating to you, Michael, is I can set the motion along with the PCC, hear it all at that time, or I can give you a date for this separate and apart from the PCC.
I would like a date separate and apart. This motion is not determinative of those records. It is prior to those records. So a date to hear this motion prior to receiving those records would be our request.
Right, but I mean, presumably, actually, you're then talking about 3 hearings because there's going to have to be a hearing on the motion to determine whether or not you'd be entitled to a hearing, an evidentiary hearing. Then, if necessary, I'd have to set the evidentiary hearing. And then we would also have the PCC.
That is accurate. So a suggestion may be to whatever the court desires.
Oh, you don't want that. You know, okay, that's fine.
You know, this is a lot. So in the expedience, we'll leave it to the court's discretion as to how you want to set things.
That part of it, but we'll try to get through it as quickly and as expeditiously as possible. But the people have seen the motion. How long are you going to need to respond to the motion for the first part?
So although I was aware that a motion was filed this morning, I was not served with a copy until moments ago. I have obtained a copy through the court file prior to being here right this moment and have had an opportunity to begin to flip through it. I have not consumed it in its entirety.
Right.
How long to respond was the court's question?
Yes. For the first part of a determination as to whether or not there would even need to be an evidentiary here in this case.
Court's pleasure, but at least a week.
At least a week. And well, they even have to set it on an off day. Monday morning. If I give it 10 days. I'm just going to give her a reason for 10 days. And then just give me a week to go through everything. So around this time. Yeah. Okay, so. Okay. Will that work?
Let me make sure.
So with reference to the motion, I'll have the prosecutor's response will be due by even longer than a week, February 2nd.
Thank you.
February 2nd, 2026. I will then set this for hearing on the motion. For February 9th, 2026, at 1 p.m.
Your Honor, may I speak up?
Yes, go ahead.
In the moment, I have a murder case set to start on that date.
That's-
That may
that's-
change, even within the end of the day today, that may get moved. But in the moment, that is day one of the murder trial.
That's day one.
That's not a good date for me either, Judge.
16. Just give me a date and let's see what we can figure out. Well, Tuesday the 10th is not going to work if the murder trial goes. So
Tuesday the 17th at 2:00. Should be fine.
That works for me.
at what time?
2 p.m.
All right. So the motion will be set for February 17, 2026. You said 2
Yes, sir.
at 2 p.m. Okay, and that will be an in-person hearing. We then, in understanding that, depending on the result of that motion, there may be another date that is set. But I'm not going to deal with that at this point because a determination has to be made. So I'll adjourn the probable cause conference. Folks, normally I'm not really going to care about the date itself, but with all some of the logistics that come along with this case, I have to because of other docketing concerns. Will March 19th then work? I realize that's a little bit longer than what you asked for, but we're going to see each other on the 17th. And then I would adjourn this out to the 19th, hoping that all discovery, at least at that point, is clear.
That works for the defense.
Works for me as well. Thank you.
All right. So probable cause conference will be adjourned to March 19th, 2026, 9 a.m. whereas your invite indicates. Is there anything else, Roger?
Nothing for me.
No, Your Honor.
All right.
Thank you very much.
Bond will continue.
Thank you.
Thank you. Court does call the case, People versus Francisco Quazada Loretta.
Assistant Public Defender.